initiatives, and it's perhaps unprecedented that we'll find ourselves moving towards the impression or expectation as legislatures that we will be involved with regulations as well. Could I get an opinion on legal counsel if that's perhaps where we might find ourselves in terms of the legislative process? I'm seeking an opinion in terms of the legislative process, whether regulations is part of this process as well. Merci.
Thank you, Madam Law Clerk.
Thank you very much, Mr. Chair. Mr. Chair, this particular motion, what it does is it tries to have included in the annual report the royalties that are paid by each mine rather than the royalties that are paid generally. There is a broader issue of the amount of requirements that are going to be found in the regulations, and typically requirements are either in a bill or they can be in regulations. This bill sets a structure, and a lot of the detail will in fact be set forth in regulations. And regulations are generally an executive function. They're generally done either by cabinet or by ministers, not by legislative assemblies on the floor of the House. Some jurisdictions have committee scrutiny of regulations. We're not one of those jurisdictions, Mr. Chairman. So that's really on just the broad process. But this particular motion from Mr. O'Reilly really doesn't deal with regulations. It simply deals with compelling the minister to include the amount of royalties in the annual report that is required under the new clause 17.1. I hope that's helpful, Mr. Chairman.
Thank you. Mr. Nadley, to the motion.
Thank you, Mr. Chair. I think that makes it clear for me.
Thank you. To the motion, seeing nothing, I will allow the mover to conclude debate. Mr. O'Reilly.
Thanks, Mr. Chair. Yeah, this is going to be a long evening. Sorry for that, but I haven't heard a commitment out of the minister to actually make this fiscal regime review that he's talked about actually open to the public. He talks about how he's willing to make sure that the regulations that are developed in the future are going to be open to the public, but not the fiscal regime review. So I've also heard some arguments that this somehow is ridiculous, that this kind of disclosure might be required, and that payments to Indigenous governments might have to get disclosed or something. Well, actually, the federal legislation does require that now. If you go and look, you can find out how much DIVEC paid to the Indigenous governments on an annual basis. That's disclosed in the Extractive Sector Transparency Measures Act webpage. That's a requirement. This is part of a worldwide movement towards greater corporate transparency. I mentioned the extractive sector or the extractive industry transparency initiative. This is part of global requirements that industry becomes more transparent about the payments that they make. Governments should get more transparent about the payments they receive. I have yet to hear any good reasons from the minister why this information cannot be disclosed. So I would hope that members will support this, and I would request a recorded vote, Mr. Chair. Thank you.
The member has requested a recorded vote. All those in favor, please rise.
The member for Frame Lake. The member for Yellowknife North. The member for Nahende.
All those opposed, please rise.
The member for Decho. The member for Nunavut. the member for Inuvik Boot Lake, the member for Range Lake, the member for Great Slave, the member for Yellowknife North, the member for South, sorry, the member for Inuvik Twin Lakes, the member for Hay River South, the member for Thabacha, the member for Mackenzie Delta, the member for Saw 2, and the member for Cam Lake.
All those abstaining, please rise.
The member for Yellowknife Center.
The results of the recorded vote are 3 in favor, 12 opposed, 1 abstaining. The motion is defeated. It's time for dinner. I'm calling a recess. Thank you, committee. now call Committee of the Whole back to order. Committee to clause 17.1. Does committee agree? Thank you, committee. To clause 18. Clause 19. Clause 20. Minister Abernathy.
Thank you, Mr. Chair. I have a motion that Clause 20 of Bill 34 be amended by deleting paragraph G and substituting the following. G. Lands that have been designated by the Minister as restricted under Section 22, except for those interests described as unaffected by a designation in subsection 22 brackets 12. Thank you, Mr. Chair.
Thank you, Minister. There's a motion on the floor. The motion is in order. To the motion. Minister Abernathy.
Thank you, Mr. Chair. Mr. Chair, this motion is intended to clarify that mineral interests that existed in an area prior to an area's designation as restricted under Section 22 are unaffected by the restricted area designation. Thank you, Mr. Speaker.
Thank you. To the motion. Question has been called. All those in favor? All those opposed? Motion is carried. To clause 20 as amended. Mr. O'Reilly.
Thanks, Mr. Chair. So when I look at clause, sorry, we're on clause 22, or sorry, 20, but I'm trying to determine why the wording in 2212, which is about, says, for greater certainty, a designation made under this section does not affect any interest minerals issued in respect to the area in the designation before the designation is made, including any right of renewal. Trying to understand why we needed to make that change, Mr. Chair. Can I get an explanation from the minister's staff? Thank you.
Thank you. Ms. Farina.
Thank you, Mr. Chair. It's just a for greater clarity clause that accompanies 2212 because Section 22 is the process and I guess the 22 sets out the designation of the restricted area and how the designation happens, but it's actually Section 20 that affects the prohibitions during the time of the designation. So it's just an accompaniment to 2212 for greater clarity. They're both for certainty and clarity. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly.
Thanks, Mr. Chair. Yeah, I'm all for providing clarity, so I'm okay with this. Thanks, Mr. Chair.
Thank you. Clause 20 as amended. Thank you, committee. Clause 21. Clause 22. Minister Abernathy.
Thank you, Mr. Chair. I have a motion that Clause 22 of Bill 34 be amended by A, striking out settlement lands in subclause brackets 1 and substituting a settlement area. B, deleting paragraphs 3B and substituting the following. B, if an area is within or overlaps with a settlement area or the asserted traditional territory of an Indigenous government or organization after the minister engages with all applicable Indigenous governments or organizations. And C, striking out the settlement lands wherever it appears in paragraph 4. B, and substituting a settlement area. Thank you, Mr. Chair.
Thank you, Minister Abernathy. There's a motion on the floor. The motion is in order. To the motion. Minister Abernathy.
Thank you, Mr. Chair. The intent of this motion is to change the term settlement lands to settlement areas as we did in motion 1. This motion would ensure language in the bill is consistent with my previous motion to change the definition of settlement lands to refer to settlement areas. Thank you, Mr. Chair.
Thank you. To the motion. Question has been called. All those in favor? All those opposed? Motion is carried. To clause 22 as amended. Mr. O'Reilly?
Thanks, Mr. Chair. I move that paragraph 22(2)B of Bill 34 be amended in each of the subparagraphs I, Roman numeral 1 and Roman numeral 2, and Roman numeral 2 by striking out "or historical" and substituting "historical or municipal." Thank you, Mr. Chair.
Thank you, Mr. O'Reilly. There is a motion. The motion is in order and is being distributed. To the motion, Mr. O'Reilly.
Thanks, Mr. Chair. So this section of the bill is all about this idea of restricted areas. And so this gives Indigenous governments the ability to request temporary restrictions on areas of up to 1 year that can be extended to 2 years for a number of purposes, including areas that might have unique archaeological, cultural, ecological, geological, or historical significance. And of course, they have to cover the minimum area, and the area can be no larger than something that might be prescribed by regulation. So this would add in to those reasons why an Indigenous government may want to seek protection of an area so that it could serve municipal purposes. And of course, some Indigenous governments actually serve as municipal governments, one being the First Nation Council in Lutzelk'e or Sambak'e or Wrigley. I think even in Sigachik, the council is basically the First Nation government. So what this would do is give those Indigenous governments the ability to say, if there's something that serves a municipal purpose, say like water or sewage treatment or a landfill, that they could request that area receive temporary protection, and that they could request that of the minister. So it's about extending this to include municipal purposes. Thanks, Mr. Chair.
Thank you. To the motion. The question has been called. All those, Mr. O'Reilly.
Thanks, Mr. Chair. I would request a recorded vote. Thank you.
The member has requested a recorded vote. All those in favor, please rise.
The member for Frame Lake. The member for Yellowknife North. The member for Cam Lake. The member for Nahende.
All those opposed, please rise.
The member for Detcho. The member for Nunakput. The member for Inuvik Boot Lake. The member for Range Lake. The member for Great Slave. The member for Yellowknife South. The member for Inuvik Twin Lakes. The member for Hay River South. The member for Thabacha. The member for Mackenzie Delta. The member for Satu.
All those abstaining, please rise.
The member for Yellowknife Center.
The results of the recorded vote are 4 in favor, 11 opposed, 1 abstaining. The motion is defeated. Clause 22 as amended. Mr. O'Reilly?
Thanks, Mr. Chair. So, before I go on to something else I'd like to do, I want to ask the minister a question about, is there anything in this section that gives municipal governments, community governments, the ability to request temporary protection of areas within their boundaries that might be covered by key municipal infrastructure. Thank you, Mr. Chair.
Thank you, Mr. O'Reilly. Minister?
Thank you, Mr. Chair. No, there is not. Thank you, Mr. Chair.
Thank you, Mr. O'Reilly.
Thank you, Mr. Chair. So can the minister explain why that isn't in here? Is there a rationale? Is there some reason why this could not be extended to community governments? Thank you, Mr. Chair.
Thank you. Minister?
Thank you, Mr. Chair. The intention with a restricted area is more to protect sensitive areas that are set for a set amount of time for the long-term and find long-term use solutions. Moreover, restricted areas are justified by unique attributes, fragile attributes that could face irreparable harm, significance tied to ethical values rather than public utilities or economic worth, urgent need for temporary protection until long-term measures may be secured. Thank you, Mr. Chair.
Thank you, Mr. O'Reilly.
Thank you, Mr. Chair. So is there any sort of legal impediments here to providing this ability to request restricted areas to municipal governments? Is there any legal impediments to doing that? Thank you, Mr. Chair.
Thank you. Minister?
Thank you, Mr. Chair. It's not the intention of this motion. As I've said, I laid out what the intention of they were. Municipal infrastructure is not any of these. Thank you, Mr. Chair.
Thank you, Mr. O'Reilly.
Thank you, Mr. Chair. So that wasn't my question. Is there anything in law that the minister can cite that would be used as justification to exclude community governments from being able to request restricted areas? Thank you, Mr. Chair.
Ms. Farina?
Thank you, Mr. Chair. Just to answer the direct question about whether there's a legal possibility or not. So I think that's not the question at hand. There may or may not be a legal possibility to build legislation, but the intent of this provision is to patch the gap between a permanent production, a permanent land use tool, and the time that it takes to apply for it. And that was not something that we felt municipal infrastructure fit within this provision. And when you develop legislation, you have to fit within the intent of the provision. So we did not build in municipality infrastructure here. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly?
Thanks, Mr. Chair. So, yeah, we did hear from the Northwest Territories Association of Communities, and I just can't recall now whether there was specific requests from individual community governments for this ability to ask for temporary restricted areas. Were there any conversations like that between the department and community governments in developing the bill? Thank you, Mr. Chair.
Thank you. Minister?
Thank you, Mr. Chair. During the public engagement session, this wasn't a concern that was raised, but maybe it was possibly raised with the Sketty's engagement. I'm not sure. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly?
Thanks, thanks, Mr. Chair. Yeah, I can certainly assure the minister that it was raised with the committee. It's in the committee report. The committee tried to work with the minister and his staff to reach some kind of resolution compromise on this, and we were unable to, so that's why it's here again before us. So I understand that this section actually deals with written reasons for why restricted areas would be declined. Process place in the bill that they could and should have gotten. So, yeah, I would look forward to. Anyways, sorry, I'm speaking to a motion, and I shouldn't have done that. Sorry, Mr. Chair.
Pardon me, could you repeat that? Sorry, Mr. O'Reilly.
Mr. Chair, I move that subclause 22, 7.1, Bill 34 be amended by adding or municipalities after governments or organizations. Thank you, Mr. Chair.
Mr. O'Reilly, there is a motion on the floor. Motion is in order and is being distributed. The motion has been distributed. To the motion, Mr. O'Reilly.
Thanks, Mr. Chair. Yeah, this would extend the ability to receive written reasons to municipal governments on if the minister declines to accept a restricted area. Thanks, Mr. Chair.
Thank you. To the motion, Mr. Testart.
Thank you, Mr. Chair. Mr. Chair, again, I think this is a very important section or important change because we have heard this concern from municipalities. I'm not sure, for whatever reason, that might have not been the case with the government's early discussions with the public engagement around this, but it's certainly something the committee found, and I think it's important that we respond to this in a meaningful way. And if we're unable to, through this, if the government can't support this amendment, and for whatever reason, we still need to find a solution. And I'm not going to reflect on the outcome of previous matters, but a number of debates have occurred over motions that have been raised so far. And I've yet to hear my colleagues, my friends across the way, raise their voices to debate in a parliament, which is imperative to inform the public record on why we're doing this or why we're not doing it. So it's a bit disappointing that these motions continue to be raised and are not being given the fullness of debate to understand their contents and understand the positions around it. And I hope that can change as we continue on this process. Thank you, Mr. Chair.
Motion. To the motion. Question has been called. I will allow the mover to close debate. Mr. O'Reilly.
Thank you, Mr. Chair. Nothing to add. I request a recorded vote. Thank you.
The member has requested a recorded vote. All those in favor, please rise.
The member for Frame Lake. The member for Yellowknife North. The member for Cam Lake. The member for Nahende.
All those opposed, please rise.
The member for Detcho. The member for Nunakput. The member for Inuvik Boot Lake. The member for Range Lake. The member for Great Slave. The member for Yellowknife South. The member for Inuvik Twin Lakes. The member for Hay River South. The member for Thabacha. The member for Mackenzie Delta. The member for Satu.
All those abstaining, please rise.
The member for Yellowknife Center.
The results of the recorded vote are 4 in favor, 11 opposed, 1 abstention. The motion is defeated. So. Clause 22 as amended. Mr. O'Reilly, you've spoken to this clause, so unless there's a procedural issue or something you'd like to raise, I'm not going to allow any more comments on this. So since you've already spoken to it, I'll allow Mr. Testart to go first, but I will put you on the list.
Thank you, Mr. Chair. So, of the issues that have been raised around protecting public infrastructure, or at least I shouldn't say that, not protecting public infrastructure, but avoiding conflict when the rights contained in this Act impact the municipal infrastructure or municipal public interests. What if the government is not content to see changes in statute? What is their approach? How are we going to resolve this and keep these matters out of the courts and provide certainty beforehand so they don't end up in the courts? Thank you, Mr. Chair.
Thank you. Minister?
Thank you, Mr. Chair. I think the point is on this whole thing, it's not the Mineral Resource Act to have that discussion. It would be a broader government discussion, and maybe that's a discussion that needs to take place with the Department of MACA. Thank you, Mr. Chair.
Thank you. Mr. Testart?
Thank you. Well, the issue is that the mineral tenure rights that are governed by this Act are impacting on municipal interests. So it is very much this piece of legislation and this department's responsibility. It might perhaps be other departments' responsibilities as well. But mineral tenure conflicts aren't governed by the City, Towns, and Villages Act, the Hamlets Act, or any other statute governing municipalities. So again, this is an issue that was raised by committee, taken very seriously by the committee. The amendments proposed by committee are not acceptable to government. So what is the government's approach to resolve this issue, to prevent future conflicts, and keep these things, keep industry and municipalities out of the courts? Thank you, Mr. Chair.
Thank you. Minister?
Thank you, Mr. Chair. And I'm going to put this on the public record again. The restricted area provision is not designed to protect things like municipal infrastructure. They are planned projects where existing issues. It's not about a municipality status. The entire restricted area provision was designed to provide an emergency tool to protect sensitive areas recently discovered from irreparable harm. It is in the spirit of reconciliation and recognize the inherent rights of Indigenous governments to their land. It also recognizes the fact that Indigenous settlement lands are generally considerably larger than those of municipalities. This makes it far more difficult for Indigenous governments to know all the facets of their lands which they need to protect. And furthermore, there's nothing preventing a municipality from petitioning the minister to create a restricted area based on the criteria set out in the Mineral Resource Act. Thank you, Mr. Chair.
Thank you. Mr. Testart?
Thank you, Mr. Chair. That criteria is incredibly limited. It is limited to archaeological, cultural, ecological, geological, or historical attributes. It does not govern infrastructure or community assets like quarries. That's the whole point of committee's direction or committee's policy direction on this. So I understand the minister does not have an answer to this question. He does not have a solution to this problem, and our municipalities once again will have to wait until a conflict arises. They hire lawyers and go to the courts, and something like a quarry is off limits for the use of that municipality for years to come. And I think that's a shameful lack of attention to a concern that committee has raised in good faith. And I do not understand why when there's a conflict between two policy directions, it has to be a flat no instead of finding compromise through other tools like regulation or public policy instruments that are available to this government, available to this minister, and available to this department. Thank you, Mr. Chair.
Thank you, Mr. Testart. Minister? Nothing from the minister. To clause 22, as amended, Mr. O'Reilly?
Thank you, Mr. Chair. I move that clause 22 of Bill 34 be amended by adding the following after subclause 7.2, 7.3. The minister shall, upon request of a municipality, consider designating an area as a restricted area within which interests in minerals may not be issued for a period of up to 1 year if A, the minister considers that the designation is required urgently and for a temporary period, B, the area is located within the boundaries of a municipality, C, the area contains sufficient municipal infrastructure or public utilities which could be negatively impacted by mineral development, And D, the area is no larger than necessary. 7.4, if the minister receives a request from a municipality for designation under subsection 7.3, the minister shall engage with all applicable Indigenous governments and organizations that may have an interest in the proposed designation. Thank you, Mr. Chair.
Thank you. There's a motion on the floor. The motion is in order. To the motion, Mr. O'Reilly.
Thanks, Mr. Chair. I know this is kind of convoluted, but this is the main motion about this issue of how municipal governments can relate to what's happening in the Mineral Resources Act. And this is where I think we should have the main argument, the main discussion, debate around this issue. So the bill now outlines a process for Indigenous governments to request temporary restrictions for areas that are of interest to them with regard to, whether they have, unique archaeological, cultural, ecological, geological, or historical significance. What this motion would do is to basically replicate that process and allow municipal governments to request areas of temporary restriction for municipal purposes within their boundaries and no larger than an area than necessary, and that the minister would consult with Indigenous governments in carrying out the consideration of that request. So, maybe the department didn't hear about this when they conducted their original consultations, but certainly committee did. And for the minister to say that because the department didn't hear about this in their consultations, I'm not going to do anything about it, that's not why I'm here, because that's what he just said, that the purpose of this is to allow for Indigenous governments to seek temporary protection. Well, here's a clause now that would give municipal governments the same sort of capability. This doesn't take away from what Indigenous governments want to do in any way. In fact, there's a requirement in here for the minister to consult with Indigenous governments before that restricted area could go be established. So, I don't really understand why this is not something that can be accomplished. This is about, trying to avoid conflict. It's consistent with encouraging good relations, building good relationships. And in fact, in some cases, First Nation governments actually are a municipal government. I mentioned that in the case of Litzel Cay, Wrigley, Sambakay, Sigachek. Those First Nation governments actually serve as the municipal governments. So they already would have the ability to ask for restricted areas, not for municipal purposes quite yet, but why wouldn't we give this ability to request restricted areas? And it's all at the minister's discretion. The minister doesn't have to do this. But if the purpose of this bill is to try to avoid land use conflicts, encourage better working relationships, why wouldn't we give this ability to municipal governments to protect key infrastructure? I just don't understand it, Mr. Chair. So in any event, I look forward to the debate and discussion. Thank you, Mr. Chair.
Thank you. To the motion, Mr. Testart.
Thank you, Mr. Chair. Over the course of questioning, we've learned that the government does, or the minister does not have a plan to deal with this situation. I think the member's motion is a good way to deal with the situation. Clearly it's in order. Clearly it's within the capacity of the government to, or the bill and the legislation to deal with this. So I see no reason why it can't be done. Again, this is a gap. We don't know how to deal with this. We have no plan to deal with this. This seems like a good plan, and I applaud the member for bringing it forward. And if there's any good reason why this shouldn't be supported, I do not see it at this point. Thank you.
Thank you. To the motion. Question has been called. I will allow last reply to the mover, Mr. O'Reilly.
Thank you, Mr. Chair. I would request a recorded vote, and I'll be better at it next time when I ask for that. Thank you, Mr. Chair.
Thank you, Mr. O'Reilly. The member has requested a recorded vote. All those in favor, please rise.
The member for Frame Lake. the member for Yellowknife North, the member for Cam Lake, the member for Nahende.
All those opposed, please rise.
The member for Decho, the member for Nunakput, the member for Inuvik Boot Lake, the member for Range Lake, the member for Great Slave, the member for Yellowknife South, the member for Inuvik Twin Lakes, the member for Hay River South, the member for Thabacha, the member for Mackenzie Delta, the member for Sawtoo.
All those abstaining, please rise.
Member for Yellowknife Center.
The results of the recorded vote are 4 in favor, 11 opposed, 1 abstaining. The motion is defeated. Clause 22 as amended. Thank you, committee. Clause 23, Mr. O'Reilly.
Or, it's 24 I wanted, sorry.
Thank you. Clause 23, does committee agree? Thank you, committee. We're speeding right through. Nothing can slow us down now. Clause 24. Minister Abernathy.
Thank you, Mr. Chair. I have a motion that Clause 24 of Bill 34 be amended. A, in subclause 1, striking out settlement lands and substituting with a settlement area. B, in paragraph 3, brackets B, by striking out settlement lands and substituting a settlement area. And C, in subclause 4, by striking out the settlement lands wherever it appears and substituting a settlement area. Thank you, Mr. Chair.
Thank you. There's a motion on the floor. It is being distributed. The motion is in order. Mr. Testart.
Mr. Chair, a point of order. I'm looking at the copy of the motion that's been distributed, and the French translation does not seem to match the English translation. There's a subclause 4, and I can read the French if you like, but I believe you have a copy of this motion as well, but I believe this motion is out of order as both sections do not match. Thank you, Mr. Chair.
We're going to take a brief, very brief 2-minute recess while I confer with my staff. Thank you. The member has raised a point of order and explained his reasons. I have come to a ruling after conferring with staff, and although on the face of it this might appear different, the fact is that the French and English versions achieve the same objective, and the additional subclause was a choice of the French language drafter to ensure that the French and English translation achieved the same thing. And for further clarity and for the comfort of the Assembly, I'm going to turn to the law clerk for perhaps more detailed explanation, or at least more eloquent. Madam Law Clerk.
Thank you much, Mr. Chairman. I doubt I can be more eloquent than you in that regard, but I can indicate that the French language drafter felt it necessary in order to replicate the same concept that is contained within the English version of Clause 24 sub C. She felt it necessary to reproduce the clause in its entirety with the exception of the changed word. And I actually have gone and compared the clause, and indeed it is replicated in its entirety with the exception of two words which appear to connote settlement area, which I'm assuming is connotes settlement area. In other words, it was felt necessary to repeat the same clause in order to achieve the same effect as contained in sub C. As a consequence, and this was necessary because both versions are equally authoritative, and it is important that they both equally and accurately express the same concept. So sometimes more language is necessary in order to do that.
Thank you, Madam Law Clerk, for that explanation. So for those who are late joining us, the motion is in order. To the motion. Question has been called. All those in favor? All those opposed? Motion is carried. To Clause 24, as amended. Mr. O'Reilly?
Thank you, Mr. Chair. So I have some remarks I'd like to make about the concept of zones, if I may. I think this is an appropriate time. And some questions. I've had a lot of difficulty understanding the rationale for these zones. The way I heard it during the clause-by-clause review was that the department wants to try to encourage mineral exploration, and that this was a way to try to do that. And I've said that I think that that's a dangerous mixing of objectives where, you know, the department is supposed to be a regulator of mineral rights and at the same time a promoter. And I think that it's not appropriate to mix those roles and the objectives in this bill, and that's what I believe this zones portion is really all about. I have not seen anything in writing from Indigenous governments in the submissions that I think committee received that I can recall, nor from industry requesting the establishment of zones. The representation we did get from industry on this part of the bill was really about continuing the current practice of prospecting permits and grandfathering that provision into the legislation, which is actually done further down in the bill, and we may get to that if we ever finish in terms of the transitional provisions. But so I'm trying to understand what the rationale is for this. Can I get the minister to provide a clear policy rationale? Thank you, Mr. Chair.
Thank you, Minister.
Thank you, Mr. Chair. Zones can be created by nomination from Indigenous governments. Zones were included in the bill to create a method for Indigenous governments to drive where and how they could attract investment within their lands if they so choose. Zones were intended to provide greater certainty for industry by indicating where Indigenous governments would welcome greater exploration, We are trying to encourage early exploration, which is fundamental to our government's position that we need exploration to foster new responsible development and hopefully results in discoveries that could be our future mines. And this is our solution to doing it in a way that we are not only respects Indigenous governments, but allows them to have a say in how they wish to benefit from mineral exploration. And we also have to remember that zones are temporary and can be adjusted with the agreement of IGOs if we have met the goal in the creation of that zone. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly?
Thanks, Mr. Chair. Okay, I don't accept all of the reasoning there from the minister, but he also neglected to indicate that 24/7 here would allow the minister to create zones on the minister's own initiative. Is that correct? Thank you, Mr. Chair.
Thank you. Minister?
Thank you, Mr. Chair. Yes, but we'd have to consult with Indigenous governments. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly?
Thank you, Mr. Chair. So great. So the minister can do this as well. And can I just get an explanation from the department what the purpose of subclause 13 in this section is? Thank you, Mr. Chair.
Thank you. Ms. Farina?
The purpose of subsection 13 in the reprint is for greater certainty clause. It's just to clarify the interpretation of this and that any zone creates an option, doesn't change the normal rules and their availability. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly?
Thank you, Mr. Chair. So, yeah, as I read this, 13 says that a person may apply for an instrument in accordance with the regulations establishing the zone or in the general regulations established under this act. So there's going to be maybe two sets of rules, terms, conditions that are established that could apply to somebody getting an instrument in a zone. So prospecting license, a mining claim, a lease. There could be two sets of rules that could apply to those instruments. Is that correct? Thank you, Mr. Chair.
Thank you. Ms. Strand?
Thank you, Mr. Chair. It's incorrect to suggest that there's two sets of rules. There's only one underlying set of rules for the Mineral Resources Act, and that's for getting and maintaining mineral interests. That lays the groundwork. The incentives that would be put in place if a zone is established would modify some of the requirements in a specified area where that zone is in place. If I can use a practical example, if you had a zone, a proponent could apply for, whatever instrument we're giving out under that zone. Alternatively, that proponent could also say, well, I'm just going to stake a regular mineral claim and follow the regular act. So that would be an example of where the overall MRA regs for mineral tenure would apply versus one that a proponent would select to follow the zone rules. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly?
Thank you, Mr. Chair. So I think the witness proved my point. It could be two sets of terms and conditions that relate to claims. One for the zone and one of general application, which I think is going to create confusion. It's created confusion in my own mind, obviously, about having two sets of rules for anyone applying for an instrument. Can someone from the department clarify whether anybody's actually requested that this ability to have what I interpret as two sets of rules for someone securing an instrument? Thanks, Mr. Chair.
Thank you. Ms. Strand?
Thank you, Mr. Chair. So this shouldn't be new. We have zones currently in the Northwest Territories, and they're referred to under the sections in the mining regulations called prospecting permits. So we're simply building on that tool. Right now, under our mining regulations, we have two zones, one north of the 68th parallel and one south of the 68th parallel. So that means the entire Northwest Territories is divided into two zones. So somebody can apply for the instrument of prospecting permit, or somebody can apply for a mineral claim, go out and stake one. So that would be two sets of rules that we currently have where people can apply for two different sets of instruments. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly.
Thanks, Mr. Chair. Well, I continue to respectfully disagree. I think this is going to create confusion, that there's two sets of rules that can apply within one zone. But I want to move on, Mr. Chair, to one other issue with regard to zones, and I neglected to raise it earlier, and it's what I consider, or what I call the race to the bottom. Governments competing with each other to try to attract investment by having lower and lower standards. And what is the department going to do to prevent that from happening? Thank you, Mr. Chair.
Thank you. Minister.
Thank you, Mr. Chair. I myself have a whole lot of confidence in our partners and Indigenous governments to effectively represent their interests. It seems certain members may not share that confidence. Zones cannot override requirements under any other legislation. The favorable terms are limited to how mineral interests are acquired and maintained. They cannot cover things like water or environmental rules, which are rightly enshrined in other legislations. We plan to set out the baseline of what kind of incentives are allowed within a zone in regulations in partnership with Indigenous governments and stakeholders. We don't believe this is all that different than regimes in place like Manitoba, Ontario, and Yukon, so members could rest assured there are examples in place. Furthermore, we believe the checks and balances offered by the Executive Council engagement with Indigenous governments is more than enough to prevent this kind of issue. We should also note the reality that exploration is driven by geology and not by incentives, and incentives are simply a tool to enhance how and where that happens. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly.
Thank you, Mr. Chair. I wish to raise a point of order. The minister is impugning motives on my part, saying that I don't have confidence in Indigenous governments. I never said that. I've never said that in this House, and I respectfully would request that he withdraw those remarks. Thank you, Mr. Chair.
Thank you. One moment. I will give the minister a chance to respond to the point of order. Minister Schuman, what's
I'll repeat exactly what I said, Mr. Chair. I said I myself have a whole lot of confidence in our partners and Indigenous governments to effectively represent their interests. It seems certain members may not share that confidence. That's what I said, Mr. Chair.
Thank you, Minister Schuman. One moment. Thank you, committee. I will rule that there is no point of order because the minister used the term may, and he did not name specific or particular members, although I can understand the member's concern as that language is perhaps has the potential to cause disorder. So like I've stated a number of times over this past week, if we can all remain civil, all respect each other's opinions, as there are many differing opinions in this assembly, and get through the next few days without any more animosity bubbling to the top. I think we'd all appreciate that, and it would make for a much more productive week for everyone. To clause 24 as amended, Mr. Testart.
Thank you, Mr. Chair. Mr. Chair, could the witnesses explain how this provision of the Act applies to prospecting permits? I hope I've got that right, but I'll just express the concern. So the Correspondence Committee heard from industry was that they were broadly supportive of zones because they've been told, or they see it as an extension of prospecting permits, or which are under the old mining regs. So could we have an explanation of how zones apply to that? Thank you.
Thank you. Ms. Strand?
Chair, so the prospecting permit, the way it is right now, is an example of an instrument that's issued in a zone. We will have to define what the new instrument is going to be in the new MRA under zones. It could be the continuation of prospecting permits as they stand now, or a modification, or something completely new. Thank you, Mr. Chair.
Thank you. Mr. Testart?
Thank you. So where can I find which part of this of the subclauses of clause 24 address the prospecting permit instrument? Thank you.
Thank you. Ms. Farina?
Mr. Chair, so within Section 24, Section 24 is the enabling authority, the new enabling authority for prospecting permits. But you'll see in 113 sub 5, there's a continuation provision. So the current regulations that are housed within the mining regulations when this comes into force will move over. They will be, by all means, open for review and improvements, but they live on under the MRA through that provision as is, unlike the rest of the mining regulations. Therefore, prospecting permits in their current form are transitioned with this bill. Thank you, Mr. Chair.
Thank you. Mr. Testart?
Thank you. So would it be fair to characterize this zone section as having nothing to do with prospecting permits in its current form because they are addressed through a transitional provision? Thank you.
Thank you. Ms. Farina?
Mr. Chair, it is related because it's actually extremely related because Section 24, the zones, is the enabling authority for prospecting permits. So without Section 24, we cannot move over the prospecting permits. That's because, as was previously said, prospecting permits is based on zones. And right now, the design is north and south of 68. Thank you, Mr. Chair.
Thank you. Mr. Testart?
Could I just get the section of the transitional provision again, covering the prospecting permits? Thank you.
Thank you. Ms. Farina?
Thank you, Mr. Chair. It's 113 sub 5. Thank you, Mr. Chair.
Thank you. Mr. Testart?
Okay. Okay, I see that now. So is the plan going forward to better define okay, so I guess we're like on the top of this, and what we've heard over the course of the debate is that this is a discrete mechanism or instrument for Indigenous governments to seek greater mining benefits or encourage more mining exploration in their co-managed areas or traditional territories. So that's the explicit purpose of this section. I think prospecting licenses, or permits rather, have a different purpose, a different policy statement. And I think that's why there's the confusion here. I agree 100% with the read that that these are enabling for those transitional provisions. But this section, it feels orphaned with the stated intent of this. So what is the plan going forward? Is it to do this through the regulations that come next? Is it to provide a legislative amendment to include another subclause that's going to contain zones, but the prospecting licenses are not clearly defined apart from that transitional provision and using this section as an instrument. So can we get some clarity on what the policy intention is moving forward as it relates to clearly defining zones as an instrument for prospecting permits apart from our transitional provision? Thank you, Mr. Chair.
Thank you, Mr. Testart. I'm going to pause your time for a moment. We're going to have to send the pages home right away so we don't violate any child labor laws, I think. But I want the Assembly to join me in thanking them for spending some long hours with us here. Thank you. Thank you to all the pages for all your work. Minister?
And we'll talk about it all at the regulation stage.
Minister, your mic is on.
Thank you, Mr. Chair. So we're going to continue prospecting permits. What we are changing is making this not just a tool for our government, but an Indigenous government-led partnership to attract responsible exploration, and we'll continue to do that when we do the regs development and have a look at it. Thank you, Mr. Chair.
Thank you, Mr. Testart.
Okay. So section 24.1 says, for the purposes of this section, applicable in respect of Indigenous governments and organizations are those Indigenous governments and organizations. So that's at the request of the zone. So how does like an industry who wants to basically obtain a prospecting permit, how do they apply for a zone? Because this section is fairly explicit that it would be an Indigenous government that would have to request a zone be created. So how does industry go about doing it? As they did with prospecting permits. Thank you.
Thank you. Ms. Farina?
Thank you, Mr. Chair. With regards to the prospecting permits, when Section 113 sub 5 comes into force, the zone is already created. It's the same zone that we effectively have under the mining regulations right now. Within that zoning system, there's an ability to, if you so choose, obtain a prospecting permit. So I think the answer to your question is that it would already be established. Thank you, Mr. Chair.
Thank you. Mr. Testart.
Okay, thank you. That's clear. So that grandfathered clause that's going to be carried over, will it be subject to the 15-year period as outlined in Clause 11? Thank you.
Thank you. Ms. Farina?
He's asking if the enabling authority, the 15-year.
The time is ticking down. Can the minister produce an answer? Ms. Farina?
Thank you, Mr. Chair. Because the new Section 24 is the enabling authority, and because 113 sub 5 says that it's the sections of the mining regulations which have the prospecting permits are deemed to be regulations establishing zones, I would think that the enabling authority applies, and therefore the 15-year rule applies, and it's subject to a review and a renewal. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly?
Thanks.
Thank you, Mr. Chair. So remain in force until amended or repealed to be regulations. Okay, so all right, so let's assume that, so that's the case. So the old system for zones, which were again a tool of government to promote exploration, they'll remain in perpetuity, but any zone requested by an Indigenous government will expire after 15 years. That seems inconsistent with how this clause works. In actual effect, if an Indigenous government requests a zone, it will operate for no longer than 15 years, and the can be renewed, but the ones that the government has created and is carrying over from the old regime last forever. So that seems to be perhaps not unfair wouldn't be the way to characterize it, but it seems to be inconsistent with Section 24. So what's the position of the minister on that?
Thank you. Minute left on the clock. Ms. Farina?
Thank you, Mr. Chair. I'm not sure if I understood the member correctly, but if I did, that is not exactly what I said. I said that they would be subject to the 15-year rule because that is the new enabling authority, and they are deemed to be established as zones, as regulations under that enabling authority. Therefore, they would be subject to a renewal. Thank you, Mr. Chair.
Thank you. 40 seconds, Mr. Testart.
Judicious or economical. So how does industry then build a new zone or create a new zone to enable prospecting permits once they expire after 15 years when the Act comes into force? Thank you, Mr. Chair.
Thank you. Minister, 20 seconds or less.
Thank you, Mr. Chair. It would be as it is set out in the Act. There would be a review of the merits, and then it would be a renewal just in the same system as the enabling authority says. Thank you, Mr. Chair.
Thank you. Mr. Tester, your time has expired. Clause 24, as amended. Mr. O'Reilly.
Thanks, Mr. Chair. I move that subclause 24(7) of Bill 34 be deleted and the following substituted. 7, a zone may be established under subsection 2, and the regulations establishing the zone may set out requirements that the minister considers appropriate on the minister's own initiative or is recommended by the proposing Indigenous government or organizations after A, the minister engages with the applicable Indigenous governments and organizations in respect of the requirement, and B, a reasonable opportunity has been provided by the minister for the public to provide comment on the merits of the proposed zone. Thank you, Mr. Chair.
Thank you. There's a motion on the floor. The motion is in order. To the motion, Mr. O'Reilly.
Mr. Chair, I recognize this is getting late. Committee tried to work with the minister to propose a number of changes to this concept of zones to put in some checks, and I think it's fair to say that most of those were incorporated other than what this motion proposes, which is to provide an opportunity for the public to comment on the creation of zones. And that opportunity could actually include even industry, of course, because they're part of the public as well. So, you know, whether it's an Indigenous government, the minister does this on his own accord, his or her own accord, this would provide an opportunity for the public to comment on zones. And if we're going to go to the trouble of creating these zones, the minister's already publicly said that part of the expectation is that this is going to encourage development. Well, let people weigh in and express a view about that. So that's what this is about, is affording the public an opportunity to comment on the creation of zones. Thank you, Mr. Chair.
Thank you. Continue, Mr. O'Reilly.
Thank you, Mr. Chair. I request a recorded vote. Thank you.
Thank you. To the motion, Mr. Testart.
Thank you. And, you know, I know that we're in we're 2019 and we have a very unique circumstance for governance in the Northwest Territories, and we have to continue on the path of reconciliation and respect Indigenous partners, and that they have an inherent right to self-government, and many of those self-governments have come forward. So in regards to Indigenous governments being involved in the creation of zones, I think that that's important. But at the end of the day, it is the minister who approves the zone, and the minister is a representative of the public government of the Northwest Territory for all the people of the Northwest Territories. And that is his role. So to have an opportunity for the public to comment on the establishment of the zone, which again is the minister's discretion, is not a mandatory decision that is made after an Indigenous government proposes a zone. So I don't think this, you know, it impacts the ability of the new special relationships that's been established through zones. I think this is important for scrutiny, transparency, and allow everyone to weigh in, including industry, including civil society, and hold a public representative of government making decisions on behalf of the public government to to have those decisions appropriately scrutinized and held to a level of transparency that the public expects in 2019 as well. Thank you, Mr. Chair.
Thank you. To the motion. Question, well, Mr. Nakamayak.
Thank you, Mr. Chair. Mr. Chair, like other motions, I think this is getting into the weeds of some of these clauses, and I think it's a disrespect to Indigenous governments. And sometimes I'm listening to this, I'm hearing this might be mistaken with the Public Lands Act. If I'm, correct me if I'm wrong, but it definitely sounds that way. And Mr. Chair, for the sake of effectiveness and and expediency, I think that we need to really get to the point of this and stay on point and focus on what's here. Thank you, Mr. Chair.
Thank you. To the motion. The mover has the right to last reply, Mr. O'Reilly.
Thanks, Mr. Chair. My job is to actually get into the weeds. That's why I'm here. And I don't take kindly to, and I tried to correct the minister on this, I'm not disrespectful of Indigenous governments. This does not take away from Indigenous governments by any stretch of the imagination. Those rights are already protected in other provisions in the bill. This is about affording the public an opportunity to comment on the establishment of regulations and that would establish zones. The minister doesn't even have to listen to whatever the public says. In fact, anyways, I could say something about how that's played out in the context of this public consultation around this bill, but there's nothing in here that's disrespectful of Indigenous governments by any stretch of the imagination. Thanks, Mr. Chair.
Thank you. The member has requested a recorded vote. All those in favor, please rise.
The member for Frame Lake. The member for Yellowknife North. The member for Cam Lake. The member for Nahende.
All those opposed, please rise.
The member for Decho. The member for Nunakput. The member for Inuvik-Boot Lake. The member for Range Lake. The member for Great Slave. The member for Yellowknife South. The member for Inuvik Twin Lakes. The member for Hay River South. The member for Thabacha. The member for Mackenzie Delta. And the member for Satu.
All those abstaining, please rise.
The member for Yellowknife Center.
The results of the recorded vote are 4 in favor, 11 opposed, 1 abstention. The motion is defeated. Committee, we are on clause 24 of probably altogether around 120 clauses. So we're about a quarter of the way through this, and everyone's getting a little testy. I can tell. So what we're going to do is we're going to take a break, and we're going to come back after people have a few minutes to calm down, maybe get some fresh air. We're in recess. I'll now call Committee of the Whole back to order. Committee Clause 24 as amended, Mr. O'Reilly.
Thanks, Mr. Chair. I move that subclause 2413 of Bill 34 be deleted and the following substituted. 13. If a zone is established under this section, any person seeking to apply for an instrument in that zone must apply in accordance with the regulations establishing that zone. If those regulations differ from the general regulations established under this Act and may not rely, sorry. I'm going to start over, Mr. Chair, sorry. That subclause 2413 of Bill 34 be deleted and the following substituted. 13. If a zone is established under this section, any person seeking to apply for an instrument in that zone must apply in accordance with the regulations establishing that zone. If those regulations differ from the general regulations establishing this Act and may not rely on the general regulations established under this Act to apply for an instrument in that zone. Thank you, Mr. Chair.
Thank you, Mr. O'Reilly. There's a motion on the floor. The motion is in order to the motion. Mr. O'Reilly.
Thank you, Mr. Chair. I know that's a mouthful, but what this, the drafting of this motion is to say that there's two sets of rules that apply, one inside a zone and one outside of a zone. The way this had been drafted, it looked like to me that there was the potential for two sets of rules to apply within a zone. The special rules established by the regulation setting up the zone, and then the whatever rules are established in the regulation, the general regulations established under this Act. So that's what the purpose of this is. One set of rules, whether you're inside or outside of a zone. When you're inside, you live with the rules that are established by regulation to set up that zone. When you're outside, the general regulations apply or conditions set out therein. So I think this provides some clarity. You're inside a zone, one set of rules. You're outside, the other rules apply. Thank you, Mr. Chair.
Thank you. To the motion. I'll put the question to committee. All those in favor? All those opposed? Motion is defeated. Clause 24 is amended. Does committee agree? Thank you, committee. Clause 25. Clause 26. Clause 27. Clause 28. Minister Abernathy.
Thank you, Mr. Chair. I'd like to move a motion that paragraph 28, brackets 5, brackets A of Bill 34 be amended by striking out the settlement lands and substituting a settlement area. Thank you, Mr. Chair.
Thank you, Minister. There's a motion on the floor. Motion is in order. The motion has been distributed. To the motion. Question has been called. All those in favor? All those opposed? Motion is carried. Clause 28 as amended. Mr. O'Reilly.
Thank you, Mr. Chair. I'd like to know from the Minister if there's any provisions in Section 28 that provide for a municipal government to receive notice of an application to record a claim, a mining claim. Thank you, Mr. Chair.
Thank you, Minister.
No. Thank you, Mr. Chair.
Thank you, Mr. O'Reilly.
Thank you, Mr. Chair. So can the Minister tell us why municipal governments were not included in those that could receive notice? Thank you, Mr. Chair.
Thank you. Minister.
Thank you, Mr. Chair. We see this motion as unnecessary as municipal or local governments are effectively already required to receive notice. All of the public would receive notice.
Minister, there's no motion on the floor. The member had a question in relation to the clause. There's no motion to discuss. Minister.
Thank you, Mr. Chair. All of the public would receive notice under section 28.4 or brackets 4, and municipal or local governments would be able to access notice. Furthermore, we believe the positive obligation to circulate. That's it. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly.
Thank you, Mr. Chair. So yeah, although community governments could obtain the information from the public registry, is there any legal impediments or particular reasons why municipal governments couldn't be given notice of request to record a claim within their boundaries? Is there any legal impediments to that happening? Thank you, Mr. Chair.
Thank you. Minister?
I believe positive obligation to circulation notices to Indigenous governments with territory overlapping the claim application area. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly?
Thank you, Mr. Chair. So, yeah, were there any discussions that the department had with community governments or N.W.T about how to avoid land use conflicts from happening in the future, such as, providing notice to community governments of claim staking within their boundary? Thank you, Mr. Chair.
Thank you. Minister?
Thank you, Mr. Chair. Not during public engagement. There was not any discussion on that or brought forward. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly?
Thanks, Mr. Chair. Well, that's great. I'm glad to hear that the minister's department didn't actually hear any concerns about that when they were preparing the work on the bill. This committee did hear that. We've raised it. Here's another policy issue that was live, raised to the committee about how they would like to know what's going on within their boundaries. This is consistent with having good neighbor relationships, all that sort of thing that the minister talked about in his opening remarks, but there's no provision in the bill. So, Mr. Chair, I'd like to move into the motion, if I may. I move that subclause 28.5 of Bill 34 be amended A in that portion preceding paragraph A by adding, or if applicable to a municipality after Indigenous government or organization, and B in paragraph A by adding, or is within or overlaps with the land of that municipality after Indigenous government or organization. Thank you, Mr. Chair.
Thank you. There's a motion on the floor. The motion is in order to the motion. Mr. O'Reilly?
Mr. Chair, so we heard from the minister that there was no policy rationale for excluding or not including municipal governments because they didn't actually hear that concern. I said earlier that the committee certainly did hear this issue in its review of the bill. And as I said, this is about avoiding land use conflicts, about ensuring that there's good working relationships moving forward. And this does not take away from Indigenous governments in any way, but I think it recognizes that municipal governments have significant investment in infrastructure within their boundaries and want to know what's going on in their areas of jurisdiction. And without having to go and check a public registry day after day, here's an opportunity for us to provide that information to municipal government on an ongoing basis. I think this is a reasonable request to a policy concern, an issue that was raised with us, and I look forward to the minister and cabinet supporting this because I know that they believe in our community governments. Thank you, Mr. Chair.
Thank you. To the motion. Question has been called. Member has requested a recorded vote. All those in favor, please rise.
The member for Frame Lake, the member for Yellowknife North, the member for Cam Lake, and the member for Nahende.
All those opposed, please rise.
The member for Decho, the member for Nunakput, the member for Inuvik-Boot Lake, the member for Range Lake, the member for Great Slave, the member for Yellowknife South, the member for Inuvik Twin Lakes, the member for Hay River South, the member for Thabacha, the member for Mackenzie Delta, the member for Saw 2.
All those abstaining, please rise.
The member for Yellowknife Centre.
The results of the recorded vote are 4 in favor, 11 opposed, 1 abstention. The motion is defeated. Clause 28 as amended. Thank you, committee. Clause 29. Clause 30. Clause 31. Clause 32. Clause 33. Clause 34. Clause 35. Clause 36. Clause 37. Clause 38. Clause 39. Clause 40. Clause 41. Clause 42. Minister Abernathy.
Thank you, Mr. Chair. I move that paragraph 42, brackets 5A of Bill 34 be amended by striking out the settlement lands and substituting a settlement area.
Thank you, Minister. There's a motion on the floor. It is being distributed. The motion is in order. To the motion, question has been called. All those in favor? All those opposed? The motion is carried. Clause 42 is amended. Mr. O'Reilly.
Thanks, Mr. Chair. I move that subclause 42, brackets 5, Bill 34 be amended, A, in that portion preceding paragraph A by adding or, if applicable to a municipality, after Indigenous government or organization, and B, in paragraph A by adding or is within or overlaps with the land of that municipality after Indigenous government or organization. Thank you, Mr. Chair.
Thank you. There's a motion on the floor. Motion is in order. To the motion, Mr. O'Reilly.
Thank you, Mr. Chair. So this is about this new provision within the Act whereby the minister is going to require notice of intended work so that there's some understanding of what mining companies get up to when they're out there on the land. And I think this is a good thing. And I'm pleased to see that in the spirit of reconciliation, this has been, that this notice of intended work is going to be provided to Indigenous governments, and I support that. The purpose of this amendment, though, is to include municipal governments in that provision for notice so that we can avoid land use conflicts, that they can understand what's going on within their boundaries. And some of those municipal governments are actually First Nation governments, as I've said before in this House, Little Cay, Wrigley, Samba Cay, Tigachek. So this is about ensuring even those Indigenous governments know what's going on within their boundaries. Of course, they're going to get this notice here, but I think we should be treating all of our municipal governments with the same kind of process so that they can know what's going on in their backyards. So I look forward to Cabinet supporting this motion so that we support our community governments in understanding what's going on within their boundaries. And I would say that we actually did incorporate this kind of notice provision in the Public Land Act that we dealt with the other day, where now municipal governments will receive notice of land dispositions within their boundaries on the surface. So let's do it for the subsurface. That's what this is about here. Cabinet's already agreed to do it on the surface lands in the Public Land Act. The Minister of Lands agreed to do that, incorporate it into the bill, passed in this House. Let's do it now for subsurface dispositions and make sure that we work with our community governments, that we adopt a consistent approach and provide them with the kind of information they need to manage the lands and carry out their duties. So for consistency's sake and supporting our communities, I really am going to appreciate the support from my cabinet colleagues on this motion. Thank you, Mr. Chair.
The member has requested a recorded vote to the motion. Mr. Blake.
Yeah, just real briefly, keep referencing Sigachik, but actually the way that charter community is made up is we have the band that's in charge of the charter community, municipality, but the band is, once we signed our land claims, basically all our lands, a lot of our lands went over to the land claim group, so the designated Gwich'in organization actually looks after along with the Gwich'in, look after all the surrounding lands, Gwich'in lands. So, that's the responsibility of the RRC. So they always, say the charter community wants to expand their lands or protect any lands outside of the municipality, then they need to consult with the RRCs and the Gwich'in and Gwich'in Land and Water Board. So there's a huge process, and especially communities like Aklavik, where we have Gwich'in and Inuvialuit land. So it's really complicated in this area. So, in instances like this, we gotta have respect for the land claim groups, and municipalities just have to work with them. And it's not as easy as saying that the charter community could just make decisions, because it's in Sigachik, for example, there's more than one organization there, and just wanted to explain that. Thank you.
Thank you. To the motion, Mr. Testart.
Thank you, Mr. Chair. And I think the last speaker was very apt. This is a complicated set of governance in the Northwest Territories, and it gets even more complicated when you bring in designated authorities. But I think the point here is to achieve consistency that was obtained with the Lands Act, and I think land is as significant a management issue as subsurface rights. And to think that we would have municipalities informed of land transfers but not informed of intended work, it really doesn't give them the tools they need to understand what's going around them. And the community that I represent is a rather large one and has a very effective local government. And really, I see no reason why we can't afford them the same notice provisions that we've already built into another territorial statute. And I think it's important that we show that kind of respect for our municipalities, because local governance in the Northwest Territories is at the core of what we do here. And in a vast territory that's geographically separated, we have to give our local governments as many tools as they can to be effective in meeting the needs of their residents. So I strongly support this motion, notwithstanding the complexities here. If this was alien or a foreign concept, then perhaps I would have objections, but this is something that already exists in statute, and I think we should be as consistent as possible in our regulatory framework moving forward, and this does exactly that. Thank you, Mr. Chair.
To the motion, Mr. Nakamayak.
Yeah, thank you, Mr. Chair. In my region, the 4 communities that I represent, there's the municipal government, and then as well there's the community corporations which deal with benefits agreements. The municipalities, they would likely be in the administrative part of this, where they would be involved with training and possibly employment, so there would be a conflict of interest for sure at some point or another, and I think this is an example of that. So I think that there's, with all due respect to municipalities, we are part of municipalities as well too, and they're fully aware of what happens in the region. All the research applications, any type of work that goes through to the communities goes through the municipality first to approve, and also give the regulations to the mining or whatever it may be, research for that matter. So the municipalities are very well aware, and I think we're kind of confusing things and creating a conflict of interest for local and Indigenous governments. Thank you, Mr. Chair.
To the motion, Mr. Thompson.
Thank you, Mr. Chair. I represent 6 communities in the Henday. 4 of them are designated authorities, one's a hamlet and one's a village. I think each community should be treated the same and equal. In 4 of those communities that are designated authorities are Indigenous governments. And we are dealing with land issues all the time and people looking to explore around the area. So why? It's a complicated issue, and I agree, but it's across the territories. It's very complicated. I've got to be respectful of the IRC, the Gwich'in, the Sahtu. However, they also have to be respectful of the Dehcho and the Kehcho. So this is why I think this needs to be in the motion, and we need to be consistent. When we build capacity in some of these communities, when you have 2 different ways of looking at 2 different bills or 2 acts, it confuses them and confuses us, and we're not able to move forward. So I think we need to be consistent. The government needs to be consistent. This is why I believe that this motion is important and needs to be passed. Thank you, Mr. Chair.
Thank you to the motion. Question has been called. All those in favor, please rise.
The member for Frame Lake, the member for Yellowknife North, the member for Cam Lake, the member for Nahende.
All those opposed, please rise.
The member for Dehcho, the member for Nunakwa, the member for Nuvik-Boot Lake, the member for Range Lake, the member for Great Slave, the member for Yellowknife South, the member for Nuvik Twin Lakes, the member for Hay River South, the member for Thabacha, the member for Mackenzie Delta, the member for Sahtu.
All those abstaining, please rise.
The member for Yellowknife Center.
The results of the recorded vote are 4 in favor, 11 opposed, 1 abstention. The motion is defeated. To clause 42 as amended. Clause 43. Clause 44. Clause 45. Clause 46. Clause 47. Clause 48. Clause 49. Clause 50. Ms. Green.
Mr. Chair, I request that you rise and report progress. Thank you.
Ms. Green, do you wish to move a motion?
Move that the chair rise and report progress. Thank you.
There's a motion to report progress. The motion is in order and non-debatable. All those in favor? All those opposed? Motion is defeated. I'll sit here in this chair and keep going. Clause 50. Clause 51. Mr. Testart.
Thank you, Mr. Chair. Mr. Chair, this section this clause governs benefits prescribed in respect to measures to provide benefits to the people of the Northwest Territories. What is the practical instrument that's contemplated by this clause? Is it a socioeconomic agreement? Can the Minister confirm that? Thank you.
Thank you. Minister?
Yes. Thank you, Mr. Chair. Yes, it is, but we still need the flexibility. Thank you, Mr. Chair.
Thank you. Mr. Testart?
Thank you. What does that mean, we need the flexibility? I'm unclear on that. I wasn't proposing any changes to this. I was asking, is it a socioeconomic agreement? What flexibility is the Minister indicating in his response? Thank you.
Thank you. Minister?
Thank you, Mr. Chair. Legislation needs to be built in a way that can be flexible to allow for the evolution of tools we use to maximize benefits, what tools we use, and how are best left to regulations. That's because the industry is dynamic and people are dynamic, and the kinds of benefits available are dynamic and is a fast-changing industry. Adding a prospective list to the legislation would actually undermine our government's ability to be dynamic enough and act in the best interest of the residents of the Northwest Territories. Thank you, Mr. Chair.
Mr. Testart.
Thank you. I'm not sure what list the minister is referencing. There's no list that's being proposed. So I'm asking very clear questions around what this means because I'm hoping to get a clear policy intent for the public that is listening to these proceedings. If the minister could be careful to understand the questions, and I'll be careful to read them clearly. So this section is quite broad in its application. So if I'm to assume that this is to legislate socioeconomic agreements, how will that, you know, what is the government's vision for this? Is it to legislate socioeconomic agreements to be binding on the party? Thank you. On industry. Thank you.
Thank you. Minister.
Thank you, Mr. Chair. It is a tool in which is currently under review. As I've stated to the members during this assembly, this is part of the reason why we approach this provision with the flexibility in mind. Thank you, Mr. Chair.
Mr. Testart.
Well, flexibility is one way to put it. I would call it intentionally vague, and we have evidence before the committee received evidence that that's what was intended here, to make it intentionally vague so it could be plugged by regulations. My concern is that this is so wide-reaching it could cover every aspect of the mineral cycle, including exploration. Can the minister confirm that the intention of the section is solely restricted to the conditions that cause socioeconomic agreements to arise, namely production? Thank you.
Thank you. Minister.
Thank you, Mr. Chair. Our current practice is not to have it for exploration, but we want to see it for construction phase and operations, and lastly, the closure section. Thank you, Mr. Chair.
Thank you, Mr. Testart.
Thank you. That was very clear, and that's what industry is looking at when they see a section like this. It is so vague you could drive a truck through it. So having that kind of certainty. So what, you know, can this section be used if a socioeconomic agreement so signed that's governed by this section, if a company or mining project isn't able to meet the terms of the agreement, will regulations be drafted to create some sort of penalty if the agreement is breached in any measurable way? Thank you.
Thank you, Minister.
Thank you, Mr. Chair. Our current SEAs are best efforts. Government is working with the mining proponents together to meet targets and using the collaborative approach, and this has all been done without legislation. Thank you, Mr. Chair.
Thank you, Mr. Testart.
Thank you, and I think that system works very well, and yet we have this clause. So what is the intention of this clause? Is the intention of this clause to change best efforts? Sorry, what is the policy direction? Will this clause be used to change the state of play away from best efforts and towards prescribed benefits for the public? Thank you, Mr. Chair.
Thank you. Minister.
Thank you, Mr. Chair. The answer is no, but, you know, currently we use best efforts along with the proponents and Indigenous governments to make best efforts for the residents of the Northwest Territories through SEAs. Thank you, Mr. Chair.
Mr. Testart.
So just once more for clarity, the minister will confirm that the government's position on this clause is to continue the practice of best effort socioeconomic agreements moving forward into the regulations. Thank you, Mr. Chair.
Ms. Farina.
Thank you, Mr. Chair. This enabling authority allows us to put behind SCAs or whichever tool it evolves in the future to modernize our measures for benefits. It allows us to have a statutory enabling authority behind them because currently, right now, we do not have that. Within those regulations, they could be designed however appropriate, and even within, for example, socioeconomic agreements that were enabled under legislation, the content of the agreement itself could still have terms phrased as best efforts. So I don't think this enabling authority, sets any rules. It allows us to have the flexibility to work, as we said, to work with the proponent to find the best way to maximize benefits. Thank you, Mr. Chair.
Mr. Testart?
Could this section be used to enable regulations that creates a penalty regime if companies aren't able to meet their benefits governed by this section? Yes or no? Thank you.
Thank you, Mr. Testart. Ms. McLaughlin.
Thank you, Mr. Chair. There is a counterpart regulation making authority with respect to Section 51. If it's okay to note it, it's 111(1) sub U, and the language there is respecting requirements in respect of measures. So that provide benefits to the people in Northwest Territories. So requirements in respect of measures could include a series of things, but there's no more particulars that indicate that penalties would flow from parts of that requirements with respect to measures. Thank you, Mr. Chair.
Thank you, Mr. Testart.
Thank you, Mr. Chair. What I am trying to seek clarity on is A, how broad is this? And I think we've learned it's fairly broad. And B, given that most likely this will not change from its current form tonight, let's give crystal clear certainty what the government plans to do with this moving forward. I do not, and the minister can say that that there are no concerns from industry or investor confidence. But we've got correspondence that says this section's very vague. So if you could just put on the public record tonight that this is just codifying what is currently going on in the Northwest Territories, and there are no plans to change it, that would be a comfort to me and a comfort to, I think, our home audience. Thank you.
Thank you. Minister.
Thank you, Mr. Chair. The reason we have this in here is to accrue benefits for N.W.T. residents, and that's what we will continue to do, and that's why we have it in here. And we are subject to improvements going forward. Thank you, Mr. Chair.
Mr. Testart.
So I'll interpret that as no. And the fact that we don't know where this is headed, that it's incredibly broad, those were the initial concerns of committee. And I really hope that gets resolved tonight, that there's some clarity on this, because this is a big hole in this legislation that is solved by regulations, and we don't get to decide those, and we don't know what those are going to look like. So we need some certainty on this, and if all we could get is policy certainty tonight, I'd be happy, but we couldn't even get that. So I still have grave concerns around this section. Thank you, Mr. Chair.
Thank you. Clause 51. Mr. O'Reilly.
Thanks, Mr. Chair. Yeah, I too have very major concerns around Section 51. Look, I'm all for benefits, and even if we have to legislate them, I'm fine with that. It could codify best practice, but this is written in such a broad, vague, permissive fashion, it could mean anything. I understand what the minister has said he intends to do. The problem is he may not be the minister that develops the regulations in the 19th Assembly. It could be somebody else. It could be me. Imagine that. Seems unlikely. So, if this, the purpose that I heard the minister talk about earlier was providing clarity, certainty, setting out expectations, all of those good things, That's not what Section 51 does. This is the ticking time bomb in the bill. This could allow a minister to reach back into the exploration phase and require benefits. The way this is worded, it doesn't, there's no specific trigger identified. There's no specific list of benefits. Benefits don't even have a definition in the bill. I've heard what the intentions are, but that's not what this reads. So just to be really clear, what would be the trigger that would require benefits under this Section 51? Thank you, Mr. Chair. I'd like to ask that of the Minister. Thank you.
Ms. Farina.
Thank you, Mr. Chair. The set of regulations that so this is the enabling authority, and each regulation underneath this enabling authority for benefits, the measures, let's say, would have to set its trigger for that measure. For example, socioeconomic agreements. I think when you're referring to certainty, this enabling authority is meant to provide our population, the residents of the Northwest Territories, that what they expect from mining benefits is enshrined in the legislation. Thank you, Mr. Chair.
Thank you, Mr. O'Reilly.
Thanks, Mr. Chair. So the trigger is going to be set by regulation. I get that. That's the way this has been drafted. The benefits are going to be set by regulation. So there's nothing stopping a future minister from requiring benefits right back to prospecting through the entire mining cycle. Those benefits could include requiring local hiring, spending, the sort of things that we do now. They could actually involve setting penalties. This is just far too broad, Mr. Chair. There's no certainty created by this. What it looks like is the department, the minister wants to retain ultimate flexibility in defining this in the future without creating any, and you have to balance that off against the uncertainty that this is going to create. This has the potential to scare away investment because it is so broad, so vague, it could allow future ministers to reach right back to the beginning of prospecting. You know, I've heard the intention is to tie to build on socioeconomic agreements. Great. That's not what this provision does. Now, other parts of this section deal with the Indigenous government benefit agreements. That's great. There's a clear process for that. There's dispute resolution laid out. Those are going to be negotiated. There's a process laid out. It's tied to, right now, a production project. And I think we're going to talk more about that. There's a clear trigger. There's a process. There's nothing around any of that for these broad public benefits. And I'm sorry, the minister cannot, and the department cannot have their cake and eat it too. You've got to provide some level of clarity, certainty here around what this really means. And the way this bill has been drafted, it doesn't do that. Thank you, Mr. Chair. But if the minister would like to speak to this, I'd be happy to hear what he may have to say. Thank you, Mr. Chair.
Thank you, Minister. Any comments?
Comment noted.
Mr. McNeely?
Thank you, Mr. Chair. As I mentioned earlier, balancing transparency and confidence and certainty are all words of the intent that we're trying to achieve in the bill here. The N.W.T is a very diverse region with many cultures, land titleship. Therefore, there must be a design legislation and regulation to allow flexibility for those accommodations for those diverse areas. And we have a land claim which spells out an enormous amounts of comfort to the word access and benefits. Other areas don't. So there has to be some flexibility for this institution to lead towards creating those benefits that some areas may be so vague in guaranteeing benefits when a developer walks in the door. As it stands now, I'm comfortable with the way it's worded, and I'm comfortable with regulation. Thank you, Mr. Chair.
Thank you. To clause 51, Mr. Nakamayak.
Yeah, thank you, Mr. Chair. Mr. Chair, as a previous speaker mentioned, there's a lot of different Indigenous groups in the territories, some signed, some unsigned. We need the administration part of this so that we can have a body for this to work with all Indigenous governments across the territory. Thank you, Mr. Chair.
Thank you. To clause 51, Mr. O'Reilly.
Thanks, Mr. Chair. I move that Bill 34 be amended by deleting clause 51 and substituting the following. 51(1). The Commissioner, on the recommendation of the Minister, may prescribe requirements in respect of measures that provide benefits to the people of the Northwest Territories that the holder of a mineral lease must meet before being granted a production license. 2. Benefits in the measures referred to in subsection 1 may include, but are not limited to, particulars in respect of the following. A. Employment practices. B. Human resource development. C. Business development. D. Social well-being. E. Cultural well-being. F. Monitoring and reporting. G. Engagement between the parties. H. Dispute resolution. I. Any other matter that the Minister considers in the public interest. 3. The Minister may change the benefits required of a holder of a production license if there is a material change as prescribed in the project authorized by the production license. Thank you, Mr. Chair.
Thank you. There's a motion on the floor. The motion is in order. To the motion, Mr. O'Reilly.
Thanks, Mr. Chair. So, the intent of this motion is to provide the kind of clarity that the Minister has not been able to do in debates so far about, and what this does is actually codify the intentions the Minister has already spoken about, of providing benefits for people of the Northwest Territories. Those benefits can take many forms. It could be a benefit agreement. It could be prescribed by regulations. It's all at the discretion of the Minister. But what this does is establish a clear trigger of a production license. So there's an endpoint here. This is when the benefits would kick in. And furthermore, it would only be for whatever the Minister prescribes by regulations. It might be mining projects over a certain value, $50 million. Whatever it might be, it's all prescribed at the Minister's discretion. But this would establish a clear trigger. And in fact, it's the trigger the Minister's already talked about. We want to get benefits from mines that go into production. That's what this is about. The second part is a non-inclusive list of what may be considered as benefits. This list was not dreamed up out of thin air. This is a list of the table of contents of the NICO socioeconomic agreement, the last socioeconomic agreement signed by this government during this assembly. That's what this list, that's where it comes from. So it sets out an expectation that, gee, when we're talking about benefits, here's the things we are starting to mean. Of course, it's all, again, at the discretion of the Minister, because it says the Minister may include these things, and then whatever else the Minister considers in the public interest. The last part here of this 3 is if there's a change to the project in some way after the benefits arrangement has been put in place, the Minister could reconsider those benefits, reopen that. We already find that provision in the next part of the bill that we're going to deal with in terms of the Indigenous government arrangements, agreements. So this just includes that here. So it gives the Minister the option of reopening the agreements as prescribed by regulations. Those thresholds can be, and definitions of what a material change may be, they could be set out by regulation. So what this does is set out in language what the minister has already said he intends to do. This provides the kind of clarity and certainty that the minister's already talked about, and gives him the flexibility to go off and decide, he or she in the future, to decide these things at their discretion by regulation. So this accomplishes what the minister's already said he intends to do. And I think it provides the kind of clarity, certainty that industry has asked of us. So I look forward to my colleagues supporting this in the effort to provide certainty and clarity and to accomplish the things that the minister's actually said he intends to do. Thank you, Mr. Chair.
Thank you. To the motion, Mr. Van Thyn.
Thank you, Mr. Chair. You know what, in reviewing this, when we had this before committee, this is how I would have expected to see a clause like this laid out. When you want to put benefits into legislation, putting, remind folks that clause 51.1 is a may clause, sub 2 is a may clause, and sub 3 is a may clause. There's no shall here at all, so there's no obligation, absolute obligation on the minister. But what this does is this clarifies to some degree what one might expect to see when they go to this clause and read it. And that it outlines some of, not necessarily all, the benefits, and it doesn't leave one wondering or questioning what the clause was expected to do for benefits for people of the N.W.T. So I will be in support. Thank you, Mr. Chair.
Thank you. Mr. Testart, to the motion.
Thank you, Mr. Chair. Mr. Chair, I think this is a commendable effort to improve, again, a section that is far too vague. And well, part of me very much wants to see this kind of certainty and specificity added to the legislation, especially after the debate we've had on the floor so far, where we couldn't even get a straight answer that this is just going to enshrine best practices and move forward along that basis. That being said, my concern is that unlike Section 52, I'm not sure if industry has been properly consulted on this. And even though this is a discretionary clause, I would like to know firmly that all parties, all stakeholders who are engaged in this have an opportunity to weigh in on it and cooperatively develop how this is going to look. There may be an opportunity to do that in regulations, but there certainly wasn't an opportunity to do that in statute. I think the only remedy for Clause 51 is to delete the clause and let the next government work on building a better clause. So although I'm sympathetic to why this is before us, I'm not in a position to support it today. But I do truly commend the efforts of members to bring this forward. I think it's their best efforts to correct a very flawed component of this legislation. Thank you, Mr. Chair.
To the motion, I'll put the question to committee. Mr. Blake.
Thank you, Mr. Chair. Just briefly, we have any development, like say in the Cochin settlement area, we have Cochin Tribal Council, who is responsible for our economics benefit agreements. We had, anytime we've ever had any, whether it's oil and gas or pipeline work, they've had agreements with the Cochin, and they look after the best interests of the GSA, and same with the Inuvialuit, and also you've heard the Premier and Minister when they traveled to Vancouver for the Mineral Expo there, there's investors that look at this territory, at the benefit agreements that we have with Indigenous governments, and they're really impressed with how things are operating, and I do commend the member for bringing this forward, but I think what we have in place at the moment is doing well for Indigenous governments. A good example is at Tle Cho, Detan Cho. They seem to be really doing well here in this area. The this is the busiest area in the territory at the moment, and I think the way it is right now is, it always could be amended through our policies, but to put this into legislation is a little, not at this time. I'm not willing to support this at the moment. Thank you.
Thank you. To the motion. I'm going to put the question to committee. All those in favor, please rise.
The member for Frame Lake, the member for Dead-Cho, the member for Yellowknife North, the member for Nahende.
All those opposed, please rise.
The member for Nunakwood, the member for Inuvik-Boot Lake, the member for Range Lake, the member for Great Slave, the member for Yellowknife South, the member for Inuvik Twin Lakes, the member for Hay River South, the member for Thabacha, the member for Mackenzie Delta, the member for Saw-2, the member for Cam Lake.
All those abstaining, please rise.
The member for Yellowknife Center.
The results of the recorded vote are 4 in favor, 11 opposed, 1 abstaining. The motion is defeated. To clause 51. Mr. Testart.
Thank you, Mr. Chair. I would request a division on clause 51 and that the vote be recorded.
The member has requested a recorded vote. All those in favor of clause 51, please rise.
The member for Nunakwood, the member for Dead-Cho, the member for Inuvik-Boot Lake, the member for Range Lake, the member for Great Slave, the member for Yellowknife South, the member for Inuvik Twin Lakes, the member for Hay River South, the member for Thabacha, the member for Mackenzie Delta, the member for Saw-2.
All those opposed, please rise.
The member for Cam Lake, the member for Nahende, the member for Yellowknife South.
All those,
Yellowknife North, my apologies.
all those abstaining. 1 second. Can we have the microphone back on the clerk to correct that last count?
Yes, it was the member for Yellowknife North, not the member for Yellowknife South.
Thank you. All those abstaining, please rise.
The member for Frame Lake, the member for Yellowknife Center.
The results of the recorded vote are 11 in favor, 3 opposed, 2 abstentions. The clause is carried. To clause 52, Minister Abernathy.
Thank you, Mr. Chair. I move that Bill 34 be amended by deleting subclause 52 brackets 1 and substituting the following. 52 subsection 1, subject to this section, the holder of a mineral lease shall enter into an agreement for benefits in accordance with the regulations with each Indigenous government or organization that the minister considers appropriate in the circumstances. A, if an undertaking authorized under the mineral lease meets the prescribed threshold, and B, when required by regulations in respect of a production license under subsection 46 brackets 3. Wally.
There's a motion on the floor. The motion is in order. To the motion, Minister Abernathy.
Thank you, Mr. Chair. The intent of this motion is to commit the timing of a benefit agreement as being linked to a production license. Thank you, Mr. Chair.
To the motion. Mr. Testart.
Thank you, Mr. Chair. And we have committee raised these concerns around the vagueness, and I want to commend the government on trying something here to give some more certainty to the provisions that surround benefit agreements with Indigenous governments and organizations. And I think this is a much more precise point in time. It ties it to a production license, unlike the current wording of the Act, which is to a production project, which isn't clearly defined. And the A part of the clause clearly connects it with the life cycle of mining work. So I think this is a needed improvement to provide that level of specificity and clarity to industry and to Indigenous governments as well, and to anyone who's interested in knowing when these requirements are going to kick in under the legislation. So I support this clause. Thank you.
Thank you, Mr. Testart. Next, to the motion, Mr. O'Reilly.
Thank you, Mr. Chair. Yeah, during the review of the bill, I raised the issue of what was the definition of production project, because there is none in the bill, and I think that created unnecessary uncertainty. And so I'm glad to see that the minister's prepared to clarify this. I had my own motion at the clause-by-clause review to deal with this. The minister would not concur with it, and so it didn't go forward. But so I'm glad to see that something I said in clause by clause has actually made its way to the floor of the House. I guess lastly, Mr. Chair, it's rather ironic that we're going to get precision in the Indigenous government benefit agreements, the kind of precision that should have been brought to the benefits for all the people of the Northwest Territories. Thank you, Mr. Chair.
Thank you. To the motion. Question has been called. Minister Abernathy.
Thank you, Mr. Chair. I'd like to request a recorded vote.
Member has requested a recorded vote. All those in favor, please rise.
The member for Great Slave, the member for Yellowknife South, the member for Inuvik Twin Lakes, the member for Hay River South, the member for Thabacha, the member for Mackenzie Delta, the member for Sawtoo, the member for Yellowknife North, the member for Cam Lake, the member for Frame Lake, the member for Decho, the member for Nunakwa, the member for Inuvik Boot Lake, the member for Range Lake.
All those opposed, please rise. All those abstaining, please rise.
The member for Yellowknife Center.
While we're waiting for the results of the recorded vote, I just want to thank all the staff who have to stick around with us here tonight, the staff in the back, the guys in the booth, security, everyone else who's working here who I don't even know about, Sergeant at Arms, the speaker, all of them. The results of the recorded vote are 14 in favor, 0 opposed, 1 abstention. The motion is carried. Minister Abernathy.
Thank you, Mr. Chair. I'd like to move a motion that Bill 34 be amended by adding the following immediately preceding subclause 52 brackets 2. 1.2, for greater certainty, the holder of a mineral lease must satisfy the requirements in subsection 1 in respect of an Indigenous government or organization identified under that subsection by entering into any agreement with the Indigenous government or organization, provided that the agreement A contains terms in respect of benefits that will be provided to the Indigenous government or organization and its members, and B, otherwise meets the requirements of this Act and the regulations. Thank you, Mr. Chair.
Thank you. There's a motion on the floor. The motion is in order. To the motion, Minister Abernathy.
Thank you, Mr. Chair. Mr. Chair, the intent of this motion is to clarify that a benefit agreement does not have to be a separate agreement. It is also intended to make clear that as long as an agreement contains provisions providing benefits, it may meet the requirement under Bill 34. Thank you, Mr. Chair.
Thank you. To the motion. Mr. Nadley.
Thank you, Mr. Chair. Once again, I'm more likely seeking clarity, and I'll pose more likely about 2 or 3 questions to the law clerk. This is a territorial statute that we are considering at this point, is it?
Yes, Mr. Nadley, it is.
Mr. Nadley?
Thank you. Now, in speaking of Indigenous governments, the presumption is that Indigenous governments have Section 35 rights. Is that at a constitutional or federal level?
Thank you, Madam Law Clerk.
Thank you, Mr. Chair. Indigenous peoples have Section 35 rights under the Constitution Act, and those are constitutionally entrenched to Indigenous people. They would extend to Indigenous governments, but that's also a fairly complicated issue. Thank you, Mr. Nadley, or Mr. Chair.
Thank you, Madam Law Clerk. Mr. Nadley.
Okay, thank you, Mr. Chair. That's all. Thank you.
Thank you. To the motion, Mr. O'Reilly.
Thanks, Mr. Chair. I can support this motion. I raised this issue when the Tlicho government appeared before committee. Their land rights agreement actually contains provisions for the beginning, at least, of negotiations on a major mining project that is over $50 million in value. And there's a list of benefits, not unlike other ones that we've heard about here tonight, that a company has to at least initiate discussions with the Tlicho government around. So I said, well, you know, if the Tlicho government actually reached an agreement under the land rights agreement, do you think that would satisfy the requirements of the bill? And they thought that that would be the case, but they were interested in sort of seeing some language around that. And presumably that's what we've got here. So it would be helpful to actually hear at some point from the minister whether they actually consulted with the Indigenous governments in you know, drafting this, because there was a commitment made by the minister during the clause-by-clause review that that was actually going to happen. So, so I think this provides some greater clarity that this requirement for a benefit agreement with an Indigenous government is not on top of what may already be provided for in a land rights agreement, or perhaps some other arrangement that might be made outside of the statute itself. But it's not clear to me who actually makes a determination that, you know, that the requirements have been satisfied, but I'm going to hold off on that for right now. So anyways, when I raised this with the minister and his staff during clause by clause, and even before that, and they just weren't prepared to do anything about it, quite frankly. So I don't know, all of a sudden it bubbles up out of thin air that all of a sudden the minister wants to clarify this. That's great. I just wish that he had done this earlier in connection with the work that committee had done. But pleased to see it here right now, this evening. Thanks, Mr. Chair.
Thank you. To the motion, Mr. Testart.
Thank you, Mr. Chair, and I think this is a much-needed improvement as well, and I support it. It's important that we clarify this section because there was a great deal of confusion, and not just amongst industry kind of looking at the clause and trying to figure it out, and providing submissions to the committee's public consultation, but also when the committee consulted with Indigenous governments who are involved in co-drafting, there was some confusion as to what benefit agreements are. So I think this is a much-needed improvement to the bill, and I think it shows that the Northwest Territories is a place where social license is a very high priority for our industry, where they have taken great pains to ensure that the conditions contained in Indigenous land rights agreements are carried out to the letter, and that benefits are provided to the people who have used the land since time immemorial. So I'm glad that we've kind of finally can turn the page on this in the legislation, and we have provided certainty. I may have more questions after the bill if this motion amends the bill, but at this point I'm very pleased to see this, and I commend the minister for bringing it forward. Thank you.
Thank you. To the motion, Minister Abernathy.
Thank you, Mr. Chair. I'd like to request a recorded vote.
The member has requested a recorded vote. I will put the question to committee. All those in favor, please rise.
The member for Great Slave, the member for Yellowknife South, the member for Nuvik Twin Lakes, the member for Hay River South, the member for Thabatcha, the member for Mackenzie Delta, the member for Satu, the member for Yellowknife North, the member for Cam Lake, the member for Nahende, the member for Frame Lake, the member for Decho, the member for Nunakput, the member for Nuvik Boot Lake, the member for Range Lake.
All those opposed, please rise. All those abstaining, please rise.
The member for Yellowknife Centre.
The results of the recorded vote are 15 in favor, 0 opposed, 1 abstention. The motion is carried. To clause 52 as amended, Mr. O'Reilly.
Thank you, Mr. Chair. Earlier, I forget I said anything earlier. Who determines with this new wording under clause 52.2, who determines whether this other agreement or arrangement satisfies the requirements of the Act? Thank you, Mr. Chair.
Thank you. Ms. McLaughlin.
Thank you, Mr. Chair. We think that it operates with subsection 1 with the result that the minister would have to be satisfied.
Thank you. Mr. O'Reilly.
Thanks, Mr. Chair. Can I, I'm still confused. Can I ask the law clerk who determines whether this other arrangement is satisfactory? And what happens if there's a dispute? Thank you, Mr. Chair.
Thank you. Madam Law Clerk.
Thank you, Mr. Chair. Mr. Chair, Ms. McLaughlin is correct. 52.1 provides that the holder of a mineral lease shall enter into an agreement for benefits that the minister considers appropriate in the circumstances. So it would ultimately be the minister's determination, although there is the ability to enact regulations in this.
Order.
Mr. Chair, I do note that the section provides that the minister may make regulations or that the agreement shall be entered into in accordance with the regulations. I would assume that it would be likely that the regulations will address some of the parameters around this, although it then goes on to say that it is the minister's determination. And in terms of disputes, Section 54.1, which we have not come to, would likely operate to resolve disputes that may arise about the new 52 sub 1 sub 2, 1.2. Thank you, Mr. Chair.
Thank you, Madam Law Clerk. Mr. O'Reilly?
Thank you, Mr. Chair. So, yeah, okay. Looks like the minister has the ultimate discretion again. Can the minister tell us, after the clause-by-clause review, he said they were going to do some more work on this part of the bill. Can the minister confirm or tell us who he or his staff consulted with in drafting or bringing forward these motions here tonight to make this change to Section 52? Thank you, Mr. Chair.
Thank you. Minister?
Thank you, Mr. Chair. We engage with the benefit working group with the IGOs. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly?
Thank you, Mr. Chair. So this benefit working group was this representatives of the Indigenous governments, the Intergovernmental Council Secretariat? Did it include other Indigenous governments that are not members of the Intergovernmental Council, like Decho First Nations or Quechua? What is this benefit working group? Thanks, Mr. Chair.
Thank you. Wait, Minister.
Thank you, Mr. Chair. So this advisory group comes from the Intergovernmental Council, and as part of that working group as well, we talked to TAP, who was a technical advisory panel, who consisted of the Decho and the North Slave Media Alliance as well. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly?
Great. Thanks for that, and I appreciate that, and I think it shows the minister followed through with his commitment. That's great, and I think these sort of changes should and probably do require consultation with Indigenous governments. Can the minister indicate whether there was any discussions with industry on these changes? Thank you, Mr. Chair.
Thank you. Minister.
Thank you, Mr. Chair. We communicated with the Northwest Territories Nunavut Chamber of Commerce on the nature of these changes as well. Chamber of Mines in general comments. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly?
Thank you, Mr. Chair. So were any other stakeholders communicated with, Northwest Territory Association of Communities, NGOs, some of the parties that did make representations to the standing committee? Thank you, Mr. Chair.
Thank you. Minister?
Thank you, Mr. Chair. The short answer is no because of the short period of time since the clause-by-clause review. Thank you, Mr. Chair.
Thank you. Mr. O'Reilly.
Thanks, Mr. Chair. I think I made my point. Thank you.
Thank you. Clause 52 is amended. Mr. Testart.
Okay, thank you, Mr. Chair. So on the clause as amended, the new clause 1.2 B says that's saying that the requirements in subsection 1 can qualify if there's an existing agreement, but it also speaks to regulations. So just for greater certainty, does the government envision a situation, the minister envision a situation where, let's say, a X mining company applies for production license, they meet the qualifications of the Clecho agreement, for example, and then they go to the minister and say, we have this agreement, it meets the Clecho land rights agreement. Will the minister then say that passes muster, you've got your benefits agreement, here's your license? Is that what this does now? Thank you, Mr. Chair.
Thank you. Ms. Farina.
Thank you, Mr. Chair. That would depend on whether that agreement proportional benefits, reasonable benefits. However, I don't wish to speculate, but I think most agreements that are concluded underneath the Clecho agreement, or at least the requirement to commence negotiations, would certainly meet that requirement. Thank you, Mr. Chair.
Thank you. Mr. Testart.
Thank you, Mr. Chair. So in terms of existing land rights agreements that have conditions for benefits, will those satisfy this section? Thank you.
Thank you. Minister.
Thank you. If the IGO says it does, it does. Thank you, Mr. Chair.
Thank you. Mr. Testart.
So for greater clarity, the government will not attempt to bring forward regulations that contradict or add conditions above and beyond what are included in land right agreements. Thank you, Mr. Chair.
Thank you. Ms. Farina.
Thank you, Mr. Chair. They cannot contradict because we have a prevailing clause in the earlier section of our bill. Thank you, Mr. Chair.
Thank you. Mr. Testart.
And will they add additional requirements or will there be additional requirements put onto those agreements if they're brought forward to the minister above and beyond what are contained in the land rights agreements? Thank you.
Thank you. Ms. Farina.
Thank you, Mr. Chair. There might be different requirements because ours is for benefits and it's for a benefit agreement, and it's not exactly the same of what is reflected in the land claim agreements. However, as we said, the point of this clause is to clarify that if there's an agreement that is concluded in another manner, such as under the purposes of a land claim agreement, and it has benefits, and especially if the IGO brings to us the position that it provides appropriate benefits, then we would take it and it would meet the requirements under this act. Thank you, Mr. Chair.
Thank you. Mr. Testart.
Well, we got there. Thank you for the clarification. That's exactly what I was looking for. Now, my next question is, for an unsettled area where where a production license is sought in an unsettled area, what is the process for that? Thank you.
Thank you. Ms. Farina.
To clarify, the question is, what is the process for benefit agreements in an unsettled area? Thank you, Mr. Chair.
Mr. Testart.
Yes, where there's not an existing land rights with benefit provisions within that land rights agreement. Thank you.
Thank you. Ms. Farina.
Thank you, Mr. Chair. The process would be that which is set out within this act and the regulations in terms of a benefit agreement. But again, Section 53 clarifies that if there was another agreement that provided benefits for another purpose that existed within that unsettled territory, that if it met the requirements under this act, we would take it as a benefit agreement, and it does not need to be a separate agreement to meet our requirements. Thank you, Mr. Chair.
Thank you. Mr. Testart.
And just for greater clarity, if an Indigenous government and a company negotiate an agreement and the Indigenous government feels that it's satisfactory in an area without a signed land rights agreement, and they bring it forward, will the government accept that agreement, or will they say it's insufficient to meet the criteria set out in regulation?
Thank you, Mr. Testart. Ms. Farina?
Thank you, Mr. Chair. Because this has not come to pass yet, I will have to just try and predict. However, the point of this whole part, in terms of Section 52 and 53 and onwards, is to allow Indigenous governments to determine their own needs and whether they're met. Therefore, if an Indigenous government said that the agreement that was concluded contains benefits that are appropriate for them, then yes, I don't think we would challenge them on that. Thank you, Mr. Chair.
Thank you, Mr. Tester. Your questioning has turned a little hypothetical. You're posing hypotheticals to the witnesses. I'm sure they can be rephrased in other ways. So, Mr. Testart, just keep that in mind. Mr. Testart?
My apologies, Mr. Chair. Yes, so, but that did answer my question, and that's what I was looking for. So let's turn to regulations then. So a lot of, again, this is a section that's key for the detail coming out in regulation, and that's why my question veered into hypothetical territory. So I won't do that now. But I think it's imperative that Indigenous governments have a say on these regulations, so we can make sure, so that they can be ensured that their perspective, especially in unsigned areas, is reflected in benefit agreement requirements. But we also need to have a role for industry, so industry is comfortable with what is going on and can explain best practice over the years that they've developed in bilateral relationships with Indigenous governments and nations. So what is the role, or what is the government's planned intention moving forward on development of regulations around Section 52? Thank you.
Thank you. Minister?
Thank you, Mr. Chair. We'll continue to move forward in a spirit of partnership as we develop regulations should this bill pass. That will mean extensive engagement with our partners from Indigenous governments, industry, and other affected stakeholders. Thank you, Mr. Chair.
Mr. Testart?
Will that engagement be follow a technical working group model or some other model that the committee has familiarized itself with over the course of our review of this legislation? Thank you, Mr. Chair.
Thank you. Minister?
Thank you, Mr. Chair. We will continue to work with the IGCS and other Indigenous governments who have been invited to the table, which was the DHO and KHO and NSMA and unsettled areas. Thank you, Mr. Chair.
Thank you. Mr. Testart?
By working with the IGCS and other partners, does the minister mean a co-drafting of regulations or merely consulting with the IGCS? Thank you, Mr. Chair.
Thank you. Minister?
Thank you, Mr. Chair. We don't know what the process will be yet. We will be sitting down and having those discussions. Thank you, Mr. Chair.
Thank you. Mr. Testart?
When will a decision be rendered on moving forward on how these regulations are going to move forward? Thank you.
Thank you. Minister?
Thank you, Mr. Chair. That will be up to the 19th Legislative Assembly. Thank you, Mr. Chair.
Thank you. Mr. Testart?
Thank you, Mr. Chair. Nothing further.
Clause 52 as amended. Does committee agree? Agreed. Ms. Green?
Mr. Chair, I move that you rise from the chair and report progress. Thank you.
Thank you, Ms. Green. There's a motion to report progress. The motion is in order and non-debatable. All those in favor? All those opposed? Motion is defeated. Clause 53. Minister Abernathy.
Thank you, Mr. Chair. I move that Clause 53 of Bill 34 be amended by striking out production project and substituting undertaking authorized under the mineral lease. Thank you, Mr. Chair.
There's a motion on the floor. The motion is in order. To the motion. Minister Abernathy. Sorry, I'm not used to looking that way. Minister Abernathy.
Thank you, Mr. Chair. The intent of this motion is to make the language used in this section consistent with the amended language put forward in sections 52, brackets 1. Thank you, Mr. Chair.
Thank you. To the motion. Question has been called. All those in favor? All those opposed? Motion is carried. Clause 53 as amended. Easy. Clause 54. Mr. Testart.
I had a question to the minister on Clause 53. Is that, will that be allowed, Mr. Chair?
We haven't considered the next clause yet, so I can allow some questioning on this. Mr. Testart.
Thank you, Mr. Chair. So this section, Clause 53, deals with a change in material change to a undertaking authorized under the mineral lease. Could the minister just explain clearly what this section contemplates? Because I think there's a concern that what does a material change look like, and does that mean an entire benefit agreement needs to be shifted to reflect that change? The minister just explained how this would play out, how the department envisions this to play out in reality. Thank you, Mr. Chair.
Thank you. Ms. Farina.
Thank you, Mr. Chair. The intent of this section is to ensure that there's an enabling authority to allow us to address material changes. This is because we heard from both Indigenous governments and organizations and industry that material changes is a very sensitive issue right now with regards to certain agreements, and therefore I think we will need to work together with all interested parties in order to determine the content of these regulations. The enabling authority there is to allow us to deal with it so that we know we have the power to address it. Thank you, Mr. Chair.
Thank you. Mr. Testart.
Thank you, Mr. Chair. So the idea here is if there is a change in material change, and that shifts the. Okay, let's use the example of an agreement signed, an agreement that's authorized, that's signed pursuant to a land rights agreement that's been accepted by the minister. There's a change in material circumstances. I see where you're going, Mr. Chair. Okay, so so does this just mean that an agreement can be amended if it's brought forward as changed, or does this mean the regulations will be drafted in a way that the government can force changes if the government notes a change in material circumstances? So who's driving this? Is it the two parties who signed the agreement, or is it the government through its regulations? Thank you, Mr. Chair.
Thank you. Ms. Farina.
Thank you, Mr. Chair. As I said, this is an enabling authority to allow us to make regulations, and within those regulations, we will have to have greater discussions with both Indigenous governments and organizations and different stakeholders, including industry, in order to find the appropriate, rules and requirements around this. The intent is that, or I guess the idea behind it being that if there's a material change to the project, then perhaps there may be an adjustment needed to be made in terms of which benefits that project should provide. Thank you, Mr. Chair.
Thank you. Mr. Testart.
Nothing further.
Thank you. 53 as amended. Clause 54. Mr. Testart.
Thank you. Can the minister just provide clarity on how the dispute resolution body will operate, or will operate as pursuant to this clause? Thank you, Mr. Chair.
Thank you. Ms. Strand.
Mr. Chair, with respect to 54, the dispute resolution body, we will be engaging with our Indigenous partners on how we envision this clause working in the regulations. Thank you, Mr. Chair.
Mr. Testart.
Will industry be engaged as well? I thought this was to resolve disputes between industry and Indigenous partners. Are we just going to engage one side of the equation here? Thank you, Mr. Chair.
Ms. Strand.
Yes, thank you, Mr. Chair. Yes, it will be with our Indigenous partners and industry to find that balance. Thank you, Mr. Chair.
Thank you, Mr. Testart.
Thank you, Mr. Chair. If there is a dispute, how soon can, do we have an idea of when this clause is triggered? Is it as, I'll rephrase. Can a production license be issued if a dispute is in progress? Or does a dispute prevent the issuance of a production license? Thank you, Mr. Chair.
Thank you. Can we get an answer from the minister? Minister? I'm going to call for a short recess. Call committee of the whole back to order. Minister, do you have an answer yet? Ms. Farina.
Thank you, Mr. Chair. So in terms of what the Act says, there's only the enabling authority that establishes the jurisdiction under Section 54. However, I can speak to what is contemplated. I just want to emphasize that this is contemplated only, and as I said earlier, we do need to engage further with the IGCS and stakeholders upon this. However, what we did envision is that this dispute resolution body logically would not, there would not be things progressing that would make any determination that they made ineffective. So it would allow time for the dispute resolution body to make a decision before things moved forward regarding the content of that decision. We also envisioned that there would be a time limit on a dispute resolution body. This is very common within dispute resolution, but it's particularly, we recognize that it's particularly important here because delay can be very detrimental to industry. So the dispute resolution body is contemplated to have different time limits set upon their determinations and their hearing processes. But that would have to be set out in the regulations, and it would also have to be subject to further discussions. Thank you, Mr. Chair.
Thank you, Mr. Testart.
Yeah, thank you. And this is the first time that this information's come forward, so I appreciate learning it tonight, and that's why we are asking these questions. So in the case where there's a project that is on multiple, that multiple Indigenous organizations and governments have a claim to, does there need to be agreements in place with all of those parties before a production license is issued? Thank you.
Ms. Farina.
Thank you, Mr. Chair. I'm pretty sure I got the question. Could you please just repeat it for me? Thank you, Mr. Chair.
Mr. Testart.
Thank you. So if there are multiple Indigenous land rights holders or rights holders who are all subject to an area where there's a production project, or do they all need to have benefit agreements in place before a license will be issued? Thank you.
Thank you, Ms. Farina.
Thank you, Mr. Chair. In order to meet the requirement under this part for benefit agreements, the way the enabling authorities are set out, yes, to meet their requirement, they do need to complete the agreements with all the Indigenous government or organizations that the minister considers appropriate in the circumstances. However, that would be subject to any dispute resolution that arose, and the timing in regards to the production license would be set out in the regulations. That tether is there. It's clear that that's the phase that we're talking about, but the linkages that you're talking about are not in the bill itself. Thank you, Mr. Chair.
Mr. Testart.
Those linkages will be established via regulation. Thank you.
Thank you. Minister.
Thank Thank you, Mr. Chair, yes.
Thank you. Mr. Testart?
At this point, is there any clarity the minister can provide on what timelines are contemplated for the dispute resolution process? Thank you.
Thank you. Minister?
Thank you, Mr. Chair. That'll have to be determined when we develop regulations. Thank you, Mr. Chair.
Mr. Testart?
And again, the minister has said that this will be a decision of the 19th Assembly. Are these regulations, will they also be subject to direction from the 19th Assembly? Thank you.
Minister?
Yes, thank you, Mr. Chair.
Thank you. Can we get some order in here? Mr. Testart?
Nothing further, Mr. Chair.
Clause 54. Committee agree? Clause 55. Clause 56. Clause 57. Clause 58. Clause 59. Clause 60. Clause 61. Clause 61.1. Clause 62. Clause 63. Clause 64. Clause 64.1. Clause 65. Clause 66. Clause 67. Clause 68. Clause 69. Clause 70. Clause 71. Clause 72. Clause 73. Clause 74. Clause 75. Clause 76. Clause 77. Clause 78. Clause 79. Clause 80. Clause 81. Clause 82. Clause 83. Clause 84. Clause 85. Clause 86. Clause 87. Clause 88. Clause 89. Clause 90. Clause 91. Clause 92. Clause 93. Clause 94. Clause 95. Clause 96. Clause 97. Clause 98. Clause 99. Clause 100. Clause 101. Clause 100. Clause 103. Clause 104. Clause 105. Clause 106. Clause 107. Clause 108. Clause 109. Clause 110. Clause 111. Minister Abernathy.
Thank you, Chair. I move that paragraph 111, brackets 1A of Bill 34 be amended by striking out "and" at the end of the English version of subparagraph VI and adding the following after paragraph VI. VI.1, prescribing areas as settlement areas for the purpose of paragraph E of the definition settlement area. Thank you, Mr. Chair.
Thank you. There's a motion on the floor. The motion is in order. To the motion, Minister Abernathy.
Thank you, Mr. Chair. This just keeps the piece of legislation consistent with our previous motions. Thank you.
Thank you. To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Clause 111, Mr. O'Reilly.
Thank you, Mr. Chair. I move that Bill 34 be amended by adding the following after subclause 111, brackets 4, 4.1. The minister may establish one or more agreements with Indigenous governments or organizations in the Northwest Territories as to how the Commissioner and Executive Council will engage with those parties in exercising the regulation-making powers under this section. Thank you, Mr. Chair.
Thank you. There's a motion on the floor. The motion is in order. To the motion, Mr. O'Reilly.
Thank you, Mr. Chair. So this is to amend the regulation-making powers of Cabinet to, I think it's Cabinet. I think it's actually the Minister, to allow the Minister could, to basically authorize the Minister to enter into agreements with Indigenous governments on how the regulation making might be carried out under this bill. This is enabling. This does not require the Minister to enter into such agreements. I think this is a helpful amendment in setting out the authority for the ability for the Minister to enter into such agreements. And in fact, we actually heard from the SAW2 Secretariat Incorporated that there were efforts already underway to draft up some sort of memorandum of understanding or some sort of an arrangement for this to happen. So this would just give a legal basis or footing for this to happen, and I look forward to support from my Cabinet colleagues. Thank you, Mr. Chair.
Thank you. To the motion. The member has requested a recorded vote. All those in favor, please rise.
The member for Frame Lake, the member for Det Show, the member for Yellowknife North, the member for Cam Lake, the member for Nahende.
All those opposed, please rise.
The member for Nunakput, the member for Nuvik-Boot Lake, the member for Range Lake, the member for Great Slave, the member for Yellowknife South, the member for Nuvik Twin Lakes, the member for Hay River South, the member for Thabacha, the member for SAW2.
All those abstaining, please rise.
The member for Yellowknife Center.
The results of the recorded vote are 5 in favor, 9 opposed, 1 abstaining. The motion is defeated. To clause 111, Mr. Testart.
Mr. Chair, I move that Bill 34 be amended by adding the following after subclause 111 4.1. 4.2. Sorry, Mr. Chair. Mr. Chair, I move that Bill 34 be amended by adding the following after subclause 111 4. 4.1, a copy of each regulation that the Commissioner and Executive Council proposes to make under this Act shall be published in the Northwest Territories Gazette, and a reasonable opportunity shall be afforded to interested persons to make representations to the Minister in respect to the proposed regulations. 4.2, no proposed regulation need be published more than once under subsection 4.1, whether or not it is altered or amended after such publication as a result of representations made by interested persons as provided in that subsection. Thank you, Mr. Chair.
Thank you. There's a motion on the floor. Motion is in order. To the motion. To the motion, Mr. Testart.
Thank you, Mr. Chair. The intention of this motion is to be consistent with other pieces of territorial legislation, and notably or I guess the sole example is the Petroleum Resources Act. This same provision exists there, and it allows opportunity for the public to review regulations as they're published and to provide them with an opportunity to comment. This is something that we heard from civil society, from industry, and from Indigenous organizations as well. And I think it's important that we give the public the opportunity to weigh in on these regulations. And as this is a consistent theme that we've heard throughout the review of these bills, this I think is a good amendment to have, and it's consistent with the PRA as well. And the government did not see fit to amend the PRA to remove this provision. And although it is a federal artifact, it's one that was retained. So all this is making it consistent with the PRA. And I encourage members to support it. Thank you, Mr. Chair. And I would request a recorded vote at the appropriate time. Thank you.
Thank you. To the motion, I will put the question to committee. The member has requested a recorded vote. All those in favor, please rise.
The member for Cam Lake, the member for Nahende, the member for Frame Lake, the member for Dead the member for Yellowknife North.
All those opposed, please rise.
The member for Nunatwood, the member for Inuvik-Boot Lake, the member for Range Lake, the member for Great Slave, the member for Yellowknife South, the member for Inuvik Twin Lakes, the member for Hay River South, the member for Thabacha, the member for Mackenzie Delta, the member for Sawtoo.
All those abstaining, please rise.
The member for Yellowknife Center.
The results of the recorded vote are 5 in favor, 10 opposed, 1 abstention. The motion is defeated. To clause 111 as amended, does committee agree? Thank you, committee. Clause 112. Clause 113, Minister Abernathy.
Thank you, Mr. Chair. I move that subclauses 113(1) and 2 of Bill 34 are each amended by striking out Part 5 and substituting Part 3. Thank you, Mr. Chair.
Thank you. There's a motion on the floor. To the motion, Minister Abernathy.
Thank you, Mr. Chair. This motion is intended to make a minor administrative correction to make these transitional provisions come before us once Part 3 of the Act, which has to do with interests and minerals, comes into force rather than Part 5, which concerns benefits for people and communities. Thank you, Mr. Chair.
Thank you. To the motion. Question has been called. All those in favor? All those opposed? Motion is carried. Clause 113 as amended. Clause 114. To clause 115. To clause 116. Minister Abernathy.
Thanks, Mr. Chair. I move that Clause 116 and the heading immediately preceding Clause 116 of Bill 34 be deleted and the following substituted. 116 brackets 1, the Public Land Act, introduced in the third session of the 18th Legislative Assembly as Bill 46, is amended by this section. Brackets 2, the following provisions are repealed. Section A, Section 6, B, paragraph 6.1, brackets B, C, paragraph 52.1, brackets 1, brackets C, and brackets D. D, paragraph 61, brackets C and D. 3 paragraphs 12.1 brackets B is amended by striking out or 6, and commencement 117 brackets 1 subject to subsections 2 and 3. this act or any provision of this act comes into force on the day or days to be fixed by order of the Commissioner, brackets 2, sections 115 come into force on the day that section 18 comes into force, unless before that day the Northwest Territories Land Act has been repealed by subsection 79, brackets 2 of the Public Land Act, introduced in the third session of the 18th Legislative Assembly as Bill 46, brackets 3, section 116 comes into force on the later of the day that section 18 comes into force, or section 6 of the Public Land Act, introduced in the third session of the 18th Legislative Assembly as Bill 46 comes into force. Thank you, Mr. Chair.
Thank you, Minister. There is a motion on the floor. It is an order to the motion. Minister?
Just for clarity, Mr. Chair, the motion is intended to ensure that regardless of whether the Public Land Act or the Mineral Resources Act comes into force first, the enabling authority for the mining regulations of the Northwest Territories Land Act or the Public Land Act over mineral rights will be repealed from the appropriate statutes once the Mineral Resources Act comes into force. Thank you, Mr. Chair.
Thank you, Mr. O'Reilly.
Thanks, Mr. Chair. Yeah, I raised this issue months ago with the department, and I don't know why it's just suddenly appearing now, but this is good. The minister does listen once in a while, even if he comes in at the last minute. Thank you, Mr. Chair.
To the motion. I will put the question to committee. All those in favor? All those opposed? The motion is carried to clause 116 as amended. Thank you, committee. To the bill number and title, Bill 34, Mineral Resources Act. Does committee agree? Does committee agree that Bill 34, Mineral Resources Act, as amended, is now ready for third reading? Thank you, committee. Bill 34, as amended, is now ready for third reading. As amended. Just for clarity, Bill 34, as amended, is now ready for third reading. I want to thank the witnesses for appearing before us. You earned your money tonight. I almost said Minister Farina a few times there. Sergeant at Arms, please escort the witnesses from the chamber. What's the wish of committee, Mr. Testart?
Thank you, Mr. Chair. I move that the chair rise and report progress. Thank you.
There is a motion to report progress. The motion is in order and non-debatable. All those in favor? All those opposed? Motion is carried. I will rise and report progress.
May I have the report, member for Hay River North?
Mr. Speaker, your committee has been considering Committee Report 33-18 brackets 3 and Bill 34 and would like to report that consideration of Committee Report 33-18 brackets 3 is concluded with 7 motions adopted, that Bill 34 is ready for third reading as amended. And, Mr. Speaker, I move that the report of the Committee of the Whole be concurred with.
Do I have a seconder? Member for Mackenzie Delta. Motion's in order. All those in favor? All those opposed? Motion carried. Must see. Third reading of bills. Minister of Environment and Natural Resources.
Thank you, Mr. Speaker. Mr. Speaker, I move, second by the Honourable Member for Hay River South, that Bill 39, Environmental Rights Act, be read for the third time. And, Mr. Speaker, I would request a recorded vote. Thank you.
Massey. Member requested for a recorded vote. Motion's in order. To the motion. Question's been called. All those in favor, please stand.
The member for Nunavik Twin Lakes, the member for Hay River South, the member for Tabacha, the member for Hay River North, the member for Mackenzie Delta, the member for Sawtoo, the member for Yellowknife North, the member for Cam Lake, the member for Nahande, the member for Frame Lake, the member for Yellowknife Center, the member for Decho, the member for Nunavut, the member for Nunavik Boot Lake, the member for Range Lake, the member for Great Slave, the member for Yellowknife South.
Massey. All those opposed, please stand. All those abstain, please stand. The results of the recorded vote, 17 in favor, 0 opposed, 0 abstention. Motion carried. Bill 39 has had its third reading. Third reading of bills. Minister of Finance.
Thank you, Mr. Speaker. Mr. Speaker, I move, second by the Honourable Member for Yellowknife South, that Bill 42, an act to amend the Petroleum Products Tax Act, be read for the third time. And, Mr. Speaker, I request a recorded vote. Thank you, Mr. Speaker.
Member requested for a recorded vote. Motion's in order. To the motion. Member for Yellowknife Center.
Thank you, Mr. Speaker. Mr. Speaker, during debate about the carbon tax bill last week, I indicated that I was prepared to support it. But after reflecting on our discussions and doing some reading about carbon tax plans in other jurisdictions, I'm no longer prepared to vote in favor of this bill. There is a consensus among scientists and economists that putting a price on carbon lowers emissions and spurs innovation to find clean energy alternatives. For example, British Columbia has had a carbon tax for 11 years. Emissions have decreased by 4.7% over that period. And contrary to the false claims of those who opposed the tax, it did not kill the economy. On the contrary, BC's real GDP has grown by 19% over the same period. That's in spite of the fact that the carbon tax on fossil fuels is now double what the federal government has proposed. Mr. Speaker, this government has never demonstrated anything but hostility to imposing a carbon tax to reduce greenhouse gas emissions, including condemnation of the federal plan. The Premier tells anyone who will listen that our territory produces so little carbon on a national basis that we shouldn't even bother with a carbon tax. That's in spite of the fact that warming has accelerated here and the effects disrupt residents, traditional land use, and it's expensive to mitigate. Mr. Speaker, here's a bulletin. Size doesn't matter. N.W.T has a small population compared to all of Canada, and Canada has a small population compared to the rest of the planet. Does that mean we shouldn't respond to the climate crisis? My answer is no. The planet is burning up, and it's on all of us, individuals, all orders of government, business, and industry, to figure out how we can be part of the solution rather than part of the problem. Mr. Speaker, problems with the development of the N.W.T carbon tax legislation reach back to 2016, when the federal government introduced its pan-Canadian framework on clean growth and climate change. The Premier followed the lead of his Conservative cronies who opposed the tax. He decided to go it alone in the Northwest Territories rather than work with the federal government on modifying its backstop to meet our unique circumstances. That was a mistake, Mr. Speaker, and the result is that we are worse off. I'm going to make a comparison to Yukon and Newfoundland and Labrador. Contrary to the Finance Minister's comments yesterday, there is every reason to compare the Northwest Territories with other jurisdictions. I find that the government makes comparisons to other jurisdictions when it suits them, as the Minister of Justice did yesterday, for example, with the Public Land Act. Yukon faces many of the same issues as the N.W.T. when it comes to the cost of living, and many communities in Labrador are as remote as the high Arctic communities in the Northwest Territories. Both jurisdictions negotiated the backstop with the federal government. The result is that they are paying 4.42 cents per litre on gasoline, while here in the Northwest Territories we are set to pay 4.7 cents per litre. Likewise, Yukon and Newfoundland and Labrador are paying 5.37 cents per litre on diesel, while we are paying 5.5 cents a litre. It turns out that taking the federal offer would have saved us money on gas, the expense most N.W.T. residents are most concerned about. Mr. Speaker, our government has made much of the total rebate on home heating fuel, yet Newfoundland and Labrador has that too, and there are also exemptions on aviation fuel, off-grid diesel electricity generation, marine transportation, as well as fuel used for forestry, fishing, mineral exploration, and municipalities. Exemptions in the N.W.T. are much less comprehensive. In short, we lost out. Why didn't the N.W.T. emerge from negotiations with a similar sophisticated and comprehensive system of rebates and incentives? Mr. Speaker, Yukon and Newfoundland and Labrador started working with the federal government soon after the Pan-Canadian Framework was introduced in 2016. As a result, there was ample time to consult residents and write legislation. There was also time to create buy-in on the need to respond to the climate crisis at a personal level. In the N.W.T., the Finance Minister was unable to provide comprehensive and timely information that would have enabled the Standing Committee on Government Operations to do its job. The result is that the only public hearing was held in Yellowknife. Consulting Yellowknife is obviously not consulting the territory, given the number and diversity of communities in the N.W.T., and I understand why residents outside the capital feel shortchanged. Mr. Speaker, we are also losing out on rebates. In Yukon, there are specific rebates for a host of entities, including individuals, business, industry, municipalities, and First Nations. Yes, the N.W.T. plans to provide rebates, but this is an important but. The N.W.T. Association of Communities predicts the meager rebate to municipalities will result in increased tax levied in the regional communities and Yellowknife who are tax-based. In Yukon, government is asking municipalities to pay 0.5% on their fuel, and in return they get 1% of carbon tax revenues. Why can't it be the same way in the Northwest Territories? A vexing question for the Standing Committee on Government Operations has been management and reporting on the money collected. Yukon's response was to create a revolving fund so that we could tell whether the money collected as a tax on carbon was being used to reduce carbon. That could have happened here. We already have several revolving funds in place now, including for the Yellowknife Airport and for marine transportation services. Mr. Speaker, let's turn to rebates. The GNWT is offering an individual rebate on the carbon tax, but the federal backstop rebates are more generous than those being offered by the N.W.T. by $80 a year for a family of 4 when fully implemented. Both Yukon and British Columbia offer additional rebates for individuals living in northern and remote areas. That is not a feature of the N.W.T. legislation, even though the cost of living is obviously higher in those areas and a larger rebate makes sense. Other jurisdictions also apply means tests to their rebates so that there's more help available for low-income families than high-income families. BC provides benefits to low-income families by redistributing the carbon tax income. Again, that's a good idea, but it's not part of the N.W.T. plan. Much more could have been done to shield residents in small communities from the impact of a carbon tax. After all, they currently have the fewest alternatives to burning fossil fuel. Mr. Speaker, there are then the rebates to large emitters, the industrial operations that produce the bulk of greenhouse gases. Newfoundland and Labrador set targets for individual industrial facilities to reduce their emissions by 2% a year from 2016-17 benchmarks and to engage in a cap-and-trade system. This system applies to iron ore mines located in Labrador, pulp and paper mills, and to electricity generation. In the N.W.T., by contrast, large emitters can expect a rebate of the tax paid and access to a fund for innovation funded by the remaining 25%. They are being given a pass that is unprecedented in Yukon or Newfoundland and Labrador. The arrival of mines on the tundra increased our GHG emissions substantially. Why aren't we making polluters pay? Newfoundland and Labrador is doing it with mines that are nearly as remote as ours, located at the end of a 600-kilometer dirt road. And let's not forget, the Mining Association of Canada is on record in support of carbon taxes. They see carbon reduction as a necessary feature of responsible business. Mr. Speaker, carbon taxes that are well designed have a minimal impact on the economy. A study by the federal and territorial governments predict our GDP will decline by less than 1%, while emissions in the mining sector are predicted to decrease by 0.5% in the first year and 2.1% by 2022 with a carbon tax in place. Mr. Speaker, the carbon tax proposed by this government is wanting in comparison to other jurisdictions on almost every front, with the public policy rationale through to implementation. Although our production of greenhouse gas emissions may be comparatively small, our responsibility to reduce them is not. Harm is harm, and inaction is not an option. It is a necessity to take action. We have had an opportunity to negotiate a better plan, better for residents and better for the planet, and we blew it. Perhaps saddest of all, we failed in the opportunity to rally our citizens to take a real part in protecting our land, our families, and our way of life. I cannot vote in favor of this law. Thank you, Mr. Speaker.
Let's see. To the motion. Member for Yellowknife North.
Thank you, Mr. Chair, and while I appreciate the previous... Sorry. We were in committee the whole so long, I was so used to sitting down there. Thank you, Mr. Speaker. Mr. Speaker, while I appreciate that some other members are going to speak this evening, possibly with regard to maybe we could have negotiated a better deal, my position all along has been that I do not support a carbon tax, whether it's coming from this government or whether it's coming from the federal government. And so I believe that we are already penalized severely for where we live. This is a dark, cold territory for 8 months of the year. We are already penalized for being in this region. We're also further penalized by the cost of living. It is 20 to 30% more expensive to live here, other than maybe Nunavut. We're the second highest jurisdiction in the country to afford to live in and do business in. Thirdly, we are also penalized by not having any options, Mr. Speaker. We do not have any affordable options. We cannot go and decide to maybe go and buy an electric-powered vehicle, because here, unlike, say, Alberta, where it's 8 cents a kilowatt hour, our power is 38 cents a kilowatt hour. Just the affordability is not there. It just makes no sense to do that sort of thing. We do not have cheap fuel options. We do not have liquid or natural gas like most of southern Canada has that is much more affordable than diesel. So we just clearly do not have the option. So we live in a cold climate where we're penalized. We already live in a higher cost of living jurisdiction, and we don't have options to switch over to. And yet the federal government and our government feel that it's necessary to apply such a tax. We don't need our behavior changed, Mr. Speaker. And why? Because we're already doing good things. We were doing these good things long before a discussion of carbon tax came along. Let's look at government. Government, through our energy or through our capital asset retrofit program, has been making improvements for eons. Improvements that are paying back, by the way, making energy efficiency and savings for taxpayers. These have a positive return on investment. Other orders of government are starting to look at district energy systems. We've all been putting in biomass heaters and boilers in all of our government-owned assets for some period of time now. Why? Because these are the kinds of things that we have to look at in order to lower our energy rates. Let's talk about, for a moment, what government is doing in terms of leading by example in other areas. We've got the Inuvik windmill farm that's going to be coming. We see industry using other options. Diavik has a windmill farm. We have solar farms or solar panels popping up all over the place. We have communities starting to talk about new microgrids and other alternatives. We have potential for geothermal in the Decho region. These are all things that we were talking about and planning and strategizing about long before anybody felt that they need to slap a carbon tax on us. And, Mr. Speaker, we're also doing good things as it relates to enacting legislation and regulations. We've been doing that for a long time. Municipal governments have been doing that for a long time. EnerGuide 80 is a good thing that you can look at towards regulations that are starting to have a proof positive effect now. Put that in a number of years ago, people are building more energy efficient homes. The municipality of the city of Yellowknife now has an energy retrofit program that they're going to be able to put in place because we enabled them through changing legislation of the City, Towns and Villages Act that people can now apply to and have a more affordable way in which to put energy retrofits into their house, because they too want to live more affordably first and foremost. But then secondly, they want to reduce their carbon footprint. So again, we're going to be increasing the Arctic Energy Alliance's budget by nearly double over the next 4 years. That means we're going to be giving more rebates back to people. That will incentivize them to put in better energy efficient appliances, pellet boilers and pellet stoves, maybe replace some windows, things like that. So it doesn't matter where you look at, whether it's government, whether it's industry, whether it's communities, or whether it's individuals. Due to where we live and due to not having other options, we have been doing these things, all the right things, for a long, long time. It is shameful that the federal government of Canada felt that the 100,000 people that live in the Yukon, Northwest Territories, and Nunavut, somehow, who are the ones that are most impacted by climate change, needed to be somehow slapped a tax so that they could change their behavior somehow. This is shameful. I will not be supporting this. Thank you, Mr. Speaker.
Massey. To the motion, member for Cam Lake.
Thank you, Mr. Speaker. Mr. Speaker, Northerners expect real climate change leadership, and that means a plan that works for the N.W.T. The plan that's being proposed by the N.W.T. that's central on Bill 42 does not achieve that goal. Only one model of carbon pricing was explored and developed without adequate legislative oversight or public engagement. And although I support some form of carbon pricing in principle, such as a cap-and-trade system, I cannot support this plan that leaves unelected public servants responsible for new taxes and rebates without approval by members of this House, not to mention the significant flaws with the plan as it was laid out and has already been thoroughly debated by this honourable House. With so many decisions being pushed off to the next Assembly, there's no reason, apart from political pressure from Ottawa, why carbon tax can't wait another 4 months. Premier Kenney, our Premier's new ally in pursuing the N.W.T's agenda on the national stage, stood up to the federal government when he received a mandate from Albertans. That's what the people voted for in Alberta, and now they've received an extension till January 1st. And yet we stand down as soon as one email is sent from one political staffer. Mr. Speaker, Northerners deserve a better plan than this, and I will be not supporting this bill. Thank you.
Merci. To the motion, member for Frame Lake.
Merci, Monsieur le Président. I know it's been a long day, but I need to go on the record for my constituents so that they can see in the future what happened here tonight. I support a carbon tax as part of a comprehensive strategy for taking action on climate change. However, I don't support the Cabinet's plan. That plan is made up of 3 parts. The carbon tax bill that's before us this evening, Bill 42, which imposes basically a surcharge, a tax on some fuels. The other 2 parts of the Cabinet's strategy or approach on this includes the energy strategy. I've spoken at length about the energy strategy. It's focused on Tolson rather than building real community and household energy self-sufficiency. I've also talked about the climate change strategic framework that did not really address the failures identified by the Auditor General's Office in conducting a climate change audit of the Northwest Territories. The recommendation was that we develop real leadership, structure, organization to allow for success. We had 2 strategies previously. They both failed, and I think we're heading in the same direction. And of course, the climate change strategic framework, 44% of the greenhouse gas reductions are supposed to come from Tolson expansion. I just can't see how it's going to be accomplished, Mr. Speaker. The purpose of the carbon tax bill has always been pitched by this cabinet, by this minister, as the big bad federal government coming in here and imposing another tax on Northerners. This could have been an opportunity for us to actually face the reality of the climate crisis that's before us and start to find ways to transition to a new economy that is free of fossil fuels and build energy self-sufficiency. That's the kind of transition and leadership that we should have come from our cabinet, but it didn't. In terms of collaboration with the committee on the development of this plan, I'm not a member of the committee, but I got to sit in on a lot of the deliberations, and I can honestly say that when the committee had requested options, scenarios from the minister, nothing came forward. That information was not provided to committee. We heard from my colleague in Yellowknife Centre how some other jurisdictions have actually developed plans that I think are far superior to ours. Committee was interested in taking the bill on the road, but the minister continued to make changes to the large emitter provisions, and the committee felt that there was no way they could share that information with the public. So what's the point of taking something on the road when you can't share the latest possible information? There wasn't even a plain language summary of the changes or the bill and what it would do. So what we've ended up with, Mr. Speaker, is a bill that is a made by cabinet approach, where all the rebates, all the grants, all of that will be totally controlled by the minister in the future. We've seen a transfer of the authority of this House to a minister in a future government to set what that plan is going to look like. I just don't think this is good public policy. And there's others have spoken about the lack of public reporting in the bill. There's no requirement for public reporting of the revenues in, the revenues out. There may not even be an opportunity for the public to comment on the draft regulations that set what the rebates and grants may be in the future. Mr. Speaker, I tried to bring forward amendments to the bill to require some public reporting, require public input into the regulations. Unfortunately, they were ruled out of order because of the way that the bill had been crafted. So I tried to make changes on the floor of the House, wasn't able to because the way the bill was put together. I'm not going to go over the Yukon approach that my colleague from Yellowknife Centre spoke to very eloquently, but it does provide rebates to municipalities, First Nation governments. It does provide for revenue sharing and rebates with adjustments for those living in rural and remote communities. Mr. Speaker, we could and should have had that kind of plan here for our citizens. That's not what we got. That might still be possible in the future, but not with this bill, not with a plan that Cabinet has developed. So I cannot support Cabinet's plan. I believe it should be sent back for a more collaborative approach for the 19th Assembly to begin to take real action on climate change. Merci, Mr. Speaker.
Merci. To the motion. Member for Nahende.
Thank you, Mr. Speaker. Be real quick and short. I don't support a carbon tax. I don't think it's great. It has an impact on Northerners. Unfortunately, the federal government has come up with it and said either come up with one or we'll impose one. Therefore, I had to make a hard decision based on the information provided to me in this House. And I will, as I told the Minister, support this bill. It's about Northerners, and for me, it's about my elders that I represent. By allowing the federal government to put carbon tax onto diesel fuel, we're going to see less fuel going into their homes. Right now, it's 74%. That's what their subsidy is, according to what I've been received. We'll see this go even down further and further. And as fuel goes up, and the subsidy doesn't move anywhere, we'll see that huge impact on our elders. These are the people who brought and were our foundation in the Northwest Territories. I'm here standing up for them and saying this is not the best possible solution, but I need to tell them that this is something that we have to do. And at least it's at the original where it's going to be sold, and it makes a difference for our residents. There, at least we're not seeing that cost to it. The aviation fuel. In my communities, they have to fly in. They have to charter in. At least now they're not going to see that cost increase. That's not going to be put on to them. So these are some of the things that I had to understand and make as I vote for this bill. I appreciate my colleagues and their concerns, and I heard them. But at the end of the day, I have to do what's right for the residents of Nahende, and I will support this bill at the end of the day. Thank you, Mr. Speaker.
Merci. To the motion. Questions? Minister, go ahead.
Thank you. Thank you, Mr. Chair, and appreciate the comments that are being made. And I feel compelled to stand up and speak to whoever's left awake in the Northwest Territories at this late hour and let them know, because the messaging that they've been getting is we've been letting some of the negative messaging get out there. And we need to not do that. We need to not play politics with something as important as this. I've heard someone say that our Premier signed on to this pan-Canadian framework and he agreed with that we need to come up with a made in N.W.T. approach, and I believe we did. I believe we did. We did exactly what we said we were going to do. They recognize the uniqueness of the challenges of the Northwest Territories, so we worked with them to come up with an approach instead of just going with the stream, going with the current sometimes, which is the easiest thing to do, as we've seen so many times. We had a public engagement. We went out to the public across Northwest Territory. We tabled a what we heard document. And you can pick and choose things out of there. Of course, there can be comments in there, truthful comments about we don't want to tax. They're being honest. A lot of comments in there about, yeah, okay, we're going to be taxed, but we're worried about the cost of living. So we tried to take steps to address that. And I hear the comments about, well, this jurisdiction, that, this jurisdiction, that, this jurisdiction, that. I heard a number of comments about the Yukon. They're providing $11.7 million in rebates to individuals. Northwest Territories is providing about $18.5 million between COLO and the point of purchase rebate on heating fuel. They also provide rebates similar to N.W.T. COLO. However, they're not rebating the carbon tax on heating fuel, which results in the N.W.T., in my opinion, being superior. By providing a point of purchase on the carbon tax on heating fuel, this ensures those that pay the carbon tax, like homeowners, who pay all their bills, receive the rebate. And it doesn't require the resident to pay the carbon tax up front. This applies to businesses as well. They're not required to pay the carbon tax on heating fuel up front, because if they had to, they would have had to pass those costs on to someone, and who would they pass them on to? We recognize what this carbon tax is supposed to do. It's supposed to do our part in helping to reduce the greenhouse gas emissions on the planet, and we'll do that. But we also have an obligation to the people in Northwest Territories that we are going to try and do what we can to protect them and their well-being, and not have things to a place where it's so high that they consider moving out. I've heard about the work that another jurisdiction is doing with the mines. One jurisdiction referenced provide 100% rebate to the mining industry. How can we say we do that? Our system rebates about 84%, and some of that rebate is tied to greenhouse gas reducing initiatives. The jurisdiction in question is also not investing very much of their carbon tax, if any, into energy initiatives. Our government is expecting to invest about $8 million annually in energy initiative with carbon tax revenue. Municipal Indigenous governments will receive some money under another plan in rebate, but will pay the carbon tax on all fuels. In the N.W.T., our community governments and organizations will get the point of purchase rebate on carbon tax on heating fuel. And this is expected to save N.W.T. community government about $1.1 million in carbon tax. Electricity rates will also be protected from for the community governments. Businesses in the Yukon are being rebated some money. In the Northwest Territories, businesses are being supported through the purchase rebate on heating fuel, which in our climate, as we all know, is a big cost driver. Let's face the reality here. Let's face the reality. It's a big cost driver. My understanding from the information I got is that the Nunavut and N.W.T. Chamber of Mines doesn't agree with the Canadian Mining Association's position on carbon pricing. So we have done a lot of work. We've done the public engagement. We've listened to them. We've heard what they had to say. And for anybody to stand there and say that this government is more concerned about rebates and that, then I mean, we're trying to do our part in reducing the greenhouse gas emission. We'll continue to do that. We've had a lot of energy initiatives that have been funded by this government. We have a lot of energy initiatives that have been partially funded by the federal government in their attempt to reduce the greenhouse. Let's not use this as political pandering, Mr. Speaker, and I mean that seriously. This is something that's very serious, and I commend those who have said that as hard as this is, I'm going to bite the bullet, I'm going to support this, because of the two options, I believe what they told me, first of all. I believe our plan is better. And I will continue to defend this, because at the end of the day, the bottom line is we need to do our part. Even though our emissions are quite low compared to the rest of Canada, we'll do our part. We have to. We have to. Our climate is very important to us, so let's not sound like it's not to this minister and the people he represents and the Indigenous people that he is a part of. Don't tell me that. So we, again, I will go back to the fact that I commend those that have said this is a hard decision that they have to make. I've said that already, and I'll say it again. So, Mr. Speaker, it might look good saying that I'm opposed to the carbon tax. I want to delay the carbon tax. It's It's going to be implemented. We've been told that. It's going to be implemented. Might look good politically to say that. But reality says that this is going to be implemented, and I will not take a chance on the well-being of the people in the Northwest Territories by playing politics with something as important as this. Thank you, Mr. Speaker.
Massey. To the motion. Question's been called. All those in favor, please stand.
The member for Inuvik Twin Lakes, the member for Hay River South, the member for Tabacha, the member for Mackenzie Delta, the member for Satu, the member for Nahende, the member for Decho, the member for Nunakput, the member for Inuvik Boot Lake, the member for Range Lake, the member for Great Slave, the member for Yellowknife South.
Massey. All those opposed, please stand.
The member for Hay River North, the member for Yellowknife North, the member for Cam Lake, the member for Frame Lake, the member for Yellowknife Center.
Massey. All those abstain, please stand. The results of the recorded vote, 12 in favor, 5 opposed, 0 abstention. Motion is carried. Bill 42 has had its third reading. Third reading of bills. Minister of Finance.
Thank you, Mr. Speaker. Mr. Speaker, I move, seconded by the Honourable Member for Yellowknife South, that Bill 43, an act to amend the Income Tax Act, be read for the third time. And, Mr. Speaker, I would request a recorded vote. Thank you, Mr. Speaker.
Massey. Member requested for a recorded vote. Motion's in order. To the motion. Question's been called. All those in favor, please stand.
The member for Inuvik Twin Lakes, the member for Hay River South, the member for Tabacha, the member for Hay River North, the member for Mackenzie Delta, the member for Satu, the member for Hay River North, the member for Cam Lake, the member for Nahende. Yellowknife North, my apologies. The member for Cam Lake, the member for Nahende, the member for Frame Lake, the member for Yellowknife Center, the member for Decho, the member for Nunakput, the member for Inuvik Boot Lake, the member for Range Lake, the member for Great Slave, the member for Yellowknife South.
Even my clerk is getting tired. All those opposed, please stand. All those abstain, please stand. The results of the recorded vote, 17 in favor, 0 opposed, 0 abstention. Motion passed. Bill 43 has had its third reading. Third reading of bills. Minister of Lands.
Mr. Speaker, I move, seconded by the Honourable Member for Hay River South, that Bill 46, Public Land Act, be read for the third time. And, Mr. Speaker, I request a recorded vote. Thank you, Mr. Speaker.
Member requested for a recorded vote. Motions in order. To the motion. Member for Frame Lake.
Merci, Monsieur le Président. I know this has been a long night, but I do owe it to my constituents to tell them where I stand on this bill. This is one of the few pieces of post-devolution legislation that was not co-drafted. We established that for the record here earlier in this House. I believe that this bill was too rushed. It was not what was promised. There was to be sets of amendments for administrative purposes to the Commissioner's Land Act, Northwest Territories Land Act. We ended up with a bill that merged the two systems. The most egregious part of the bill, Mr. Speaker, in my opinion, is that it rolls back mandatory financial security for commercial and industrial land uses. That provision has been in place since 2011 in the Commissioner's Land Act. The Minister could not provide any evidence whatsoever that this has created a problem or issue, and I would have thought that the lessons learned from Giant Mine a few kilometers down the road would dictate that we continue to keep that sort of provision in place. You know, I've spent probably 25 years of my life trying to fix up the mess that's down the road. And I don't think this bill is going to make it any better. In fact, it rolls back to protections that we already have in place for the environment and our taxpayers. So I cannot be supported. I will not support the bill. Thank you, Mr. Speaker.
Massey. To the motion. Question's been called. All those in favor, please stand.
The member for Tabacha, the member for Hay River North, the member for Mackenzie Delta, the member for Satu, the member for Yellowknife North, the member for Cam Lake, the member for Nahende, the member for Yellowknife Center, the member for Decho, the member for Nunakput, the member for Inuvik Boot Lake, the member for Range Lake, the member for Great Slave, the member for Yellowknife South, the member for Inuvik Twin Lakes, the member for Hay River South.
Massey. All those opposed, please stand.
The member for Frame Lake.
Massey. All those abstain, please stand. The results of the recorded vote, 16 in favor, 1 opposed, 0 abstention. Motion carried. Bill 46 has had its third reading. Third reading bills. Third reading bills. Mr. Clerk, orders of the day.
Orders of the day for Wednesday, today, August 21st, 2019, 1:30 p.m. Prayer, minister statements, member statements, returns to oral questions, recognition of visitors in the gallery, acknowledgements, oral questions, returns to written questions, replies to the Commissioner's opening address, petitions, reports of standing and special committees, reports of committees on the review of bills, tabling of documents, notices of motion for first reading of bills, motions, first reading of bills, second reading of bills, consideration in committee of the whole of bills and other matters, Bill 45, Committee Report 29-18-3, Committee Report 32-18-3, Committee Report 34-18-3, Minister Statements 151, 158, and 211-18-3, Table Document 442-18-3, Report of Committee of the Whole, third reading of bills, Bill 34, orders of the day.
Mr. Clerk, did they get the Diana not went on the and then such a the tides did they go on the August 21, 2019 in Satanide?